Is your lordship. My lord, item number 60 of the supplementary list. 60, my lord. Of the Pharmacy Council of India matter. Day before yesterday, your lordship heard the matter at length in the last hour, my lord. Day before yesterday and fixed it today. So, my lord, in last two occasions, something last hour is comes. Yet two, my lord, may I pray affirm? Oblige.
My lord, I am praying for listing of a institution, my lord, for admission, my lord.
After vacation?
My lord, if possible before vacation.
Why?
My lord, the respondent is occupying the chair illegally, my lord, regarding appointment of vice principal, man.
30.
Oblige.
May I pray, Your Lordship? Lordship, may I pray for listing this matter for motion on Monday, Lordship?
Why Monday?
Lordship, because the vacations are coming, Lordship, anyways.
We'll have it on Wednesday.
Wednesday, Lordship.
Maybe, Lord, I beg to mention item number 48, my lord. It is withdrawal with liberty, my lord. Contempt petition, my lord. Liberty withdrawal, my lord. 48.
Withdraw question. Mr.
Asian, my lord.
Hey, Charlie.
Yes, my lord.
Then counsel for petitioner prays for withdrawal of this contempt petition with liberty to file a clause.
Hello.
I shall not treat petition is disposed of or withdraw with liberty as
May I please, Your Lordship? Lordship, I beg to mention item number 41. In this matter, Lordship, new income bench has.
Wait for your turn. Wait for your turn.
Okay.
May I please, your lordship?
Yes.
With the consent of the other side, I beg to mention item number 46. Your
Hmm.
lordship may kindly let the matter, fix the matter after vacation.
On request made by the party. This matter.
Obliged, lordship.
I beg to mention item number 12, 14 and 39, Lordship. Lordship, my senior has some personal difficulties, Lordship. Matter may be adjourned for the day only.
Who's your senior?
KDB, Lordship. Actually, her
Have you
brother,
given your mention memo?
no, Lordship.
Then
Actually, her brother-in-law expired yesterday, that's why.
India event that can be given.
on request made on behalf of MSK Devi, item 12.
12, 14 and 39.
This the matter
12, 14,
14 and
up to
39.
the
no?
summer vacation. 12,
14 and 39.
14 also same order.
And 39 also.
Also same.
I beg to mention, my lord, for listing of motion case on Monday. And
Why Monday? We'll have it on
motion,
Tuesday.
motion,
Tuesday.
and two orders case for Tuesday or Wednesday, my lord.
Orders.
Orders for.
That will be after vacation. Motion, Mr. Singh.
Please, Your Lordship. Lordship, I pray for listing a motion case on Monday, Your Lordship.
Tuesday.
May I please, your lordship? I beg to list one WPC number 3711 of 2018. List this matter on 26, your lordship.
After vacation.
Sixty-one of supplementary list for order personal appearance.
Yes. I mean, wait, please.
Item. What is this?
My lord, this is a contempt matter. Yesterday, lot many officers appeared, my lord. I think there is personal appearance of some officers today also. My lord, matter relates to my direction was issued for payment of the salary for the period during which this petitioner served. Now, apparently, my lord, the BTC authorities have not paid it. That is the allegation. Now, my lord, they say that they have released so and so amount on such and such date. But the fact of the matter is, my lord, we have filed an affidavit wherein we have given the list of our members. So they should come up with a case having regard to the list that these are the persons who have paid. That's why a claim is wrong. My lord, they're beating around the bush. They're not coming to the point. Randomly saying we have made so and so payment. If you have made the payment, kindly show that these are the names if you have paid.
Today the matter is fixed, the yesterday's order 21/6/2023.
Which order?
Yesterday's order. In 15/5, there was a direction for personal appearance of some of the officers, Respond number 15, she could not appear yesterday, because of some miscommunication. And therefore, today the matter has been fixed for her appearance. And the affidavit of that respondent number 15 has already been filed.
No,
Respondent
that
number
is
15
that is one part of the thing, but on the substantively on the contempt petition, my lord, that is our allegation.
And respondent number 15, she is holding the post of Director Elementary Education. This is a transferred subject, the respondent 15 doesn't have any role. So the direction
Who's
was
appearing in person today?
Director elementary.
Director Elementary.
Respondent 15.
Respondent 15. So Lordship will find the yesterday's order, last paragraph.
Yesterday's order?
Yes, 21/6,
Oh,
last paragraph, Sri B. goes to
1
direct
minute.
counsel.
Language. Yes.
She has appeared today, and the affidavit has been filed yesterday only. But actually, we had an impression, we understood it wrongly, that if the affidavit is filed, she did not have to appear. But there was a specific order. Because my fault,
Okay, that is all one issue.
Yes.
The
Other
other
than
issue,
Respondent number 15 has no role, because
I'm on the other issue.
yes, other
For the
they-
payment of
Yes.
the,
Yes.
that BTC has to.
yes.
Today it has come only because there one of the persons has not appeared. Today she has appeared, We have already filed our affidavit.
Appearance is one thing, that part I've
We have
considered.
filed all our affidavit, According to us, 681 person, one is has been sent twice. The 680 person has already received we have released it and they have received their dues. If there is any thing against it, they have to file a reply to our affidavit,
My lord, kindly have a look at my lord, page number 125, my lord. That's an affidavit filed by the concerned Director of Education, BTC. Page number 125, it starts. And my lord will kindly come to page number 129. These are the vague statements they have made, my lord. Page 129. That's the part of the affidavit filed by respondent number 9. That para 6, that accordingly BTC has released an amount of rupees 1 crore and odd.
1 minute, there's something wrong with the paging, I think. 129 in my is a communication of 14th March 2019.
Oh, keeping it page to Tahati Kodisha, na? And the pagination was done by them, my lord.
1 minute.
My lord, could your lordships kindly find out the additional affidavit filed by respondent number 9 on 26/23. Therefore, yesterday.
Who's respondent 9? Respondent 4.
Director of Education, BTC. Record of Hana nahi niki? My lord, it could so happen, it was filed on 20.
May not be on the record, my last.
Maybe
It come on record,
My lord, can it be done this way, my lord? Lordship may have the matter on Monday because these people are waiting for the salary, my lord.
Okay.
In the meantime, lordship may call for the directly registry to, put up all the affidavits in this case.
Affidavit we have filed for respondent on 9, 11 and 16.
9,
11 and
Certificate.
is it on record? Just check up.
No, it's on Budhwara, no? This certificate. সেইবিলাক তাহাঁতে জাকে তাকে দিব নোৱাৰো, আমি আমাৰ কিতাপ দিবই লাগিব।
Let me just have a look.
Mine.
Yesterday also you have filed one application.
Respond number
বিশ
6.
তাৰিখে ফাইল কৰিছে নেকি? 20
No, 9.
2016 আজি 22 টো পৰহি দিনা।
Respondent 15 has also filed.
Yes, my lord.
When?
My lord, I have the number, my lord. E-filing number.
কি নাম ডাইৰেক্টৰ গৰাকী?
00438/2023. Yesterday.
Respondent number 6, 4, 12.
Well, let it be on Monday, my lord. All the affidavit will be on the record, my lord,
Okay.
by that time.
Heard Mr. Kian Chowdhury, then senior counsel assisted by Mr.
P. Sharma.
P. Sharma, general counsel for the petitioner. Stop. Also heard Mr.
Yes, for respond number 9, 11, and 16.
S. Bora, then it's counsel for 9, 11, and 16. Mr.
I am for my lord, respond number 15, my lord. B. Kaushik. my lord.
P. Kaushik, learned counsel appearing for respond number 15.
So A does for 18, your lord. A does for restaurant number 18.
A. Das, respondent 18.
My lord, I'm appearing for 8, restaurant number 8. We have filed
Alright.
affidavit on 20th.
Ardar,
My lord.
learned counsel for respond number 8.
May I please, we are for 13, my lord. Already we have filed our affidavit.
R. Dubey
Mr. R. Dubey on behalf of Mr.
for respondent 1 and 13.
Lordship, I have for respond number 4.
And MS B. Buyan. Then it's senior counsel for respond number 4.
My lord, I am for respond number 12, my lord.
Mr. D. B. Bora, learned counsel for respond number 12.
Lordship, I am appearing for respondent number 5 and 6. B. Bora.
MS B. Bora, learned counsel for respond number 5
5 and
and 6. And any others?
Respondent number 2, my lord.
Respondent number 2.
My lord.
Mr.
PK Bora, my lord.
P. K. Bora, learned counsel for respond number 2. Stop. Para, respond number 15 is personally present in court and submits that she has filed her affidavit on
Yesterday, 21/6.
21/6/2023. Stop. Para. Registry is directed to verify and place the affidavit in affidavit filed by the respondents 9, 11, 16, 15 and 16 on
Oh,
record.
Lordship.
Stop. Place the matter again
On Monday, my lord.
on
26th
26.
or 27, any 26, my lord.
The personal appearance of respond number 15 is dispensed with for the.
High level.
Deep level.
Lordship, Lordship, I'm appearing for respondent number 17 in the matter. We have filed our affidavit also, my lord.
A. Chalia, the counsel for respond number.
For respondent number 17, Lordship, sir.
Item 1 of daily list.
Yeah, please, your lordship. Well, this matter is relating to promotion from assistant teacher to the headmaster of MB scholarship. And the petitioner lordship in the meantime retired. Now lordship, if the petitioner succeed lordship, at least notional benefit should be given to him. My lord,
When did you retire?
retired on 30 lordship, 09/2015.
Yes.
My lord, the petitioner
You filed
was,
this after your retirement.
my lord,
You filed this writ petition after your retirement.
no, before retirement, after filing this writ petition, the petitioner retired.
Okay.
My lord, we have challenged order of promotion of the private respondent lordship. Respondent number 5. Well, that is page 36. lordship.
Respond number 5 has been notified.
My lord, so perhaps she has also retired. Page 36 is the order
Anybody
of,
appearing for respond number 5?
let at this stage lordship, if your lordship is not interfering with that particular order,
Okay.
even that your lordship may direct the authority to provide national benefit. But what happened in this case, lordship? While I was serving as assistant teacher, my lord, the DO lordship issued a letter that is page 19. Lordship,
Yes,
requiring the petitioner to submit his willingness. Page 19, Lordship.
yes.
This is the letter of 16 December 2003. It is for information that your name has figured in the gradation list, which has been meanwhile approved by the Director of Elementary Education. Well, this is the letter written to the petitioner. As such, you are directed to submit a prayer petition seeking promotion and stating that you are willing to join in any school of the district in case you are promoted to the post of headmaster. Your prayer petition must reach this office within 22nd positively, Lordship. Thereafter, Lordship, the petitioner filed application, that is page 21, saying that he is not willing to, not willing for promotion, Lordship. That is page 21. With reference to the above, I have the honor to state that though my name was enlisted and approved in the gradation list for promotion to the post of headmaster, in this regard, I regret to say that I am not willing for promotion to the post of headmaster due to my heart disease. And subsequently, Lordship, page 23, when I queued, Lordship, I submitted an application for withdrawal of that application. Page 23. With due respect, back to state that I have submitted an application, the date on 23/12/2003, that is page 21, Lordship, already your Lordship, for the post of headmaster in respect of my school for my ill health condition. So now I am fully cured and better condition of my physical health, and I like to take search for headmastership, and kindly allow me the same. This letter, Lordship, is written by the petitioner to the DO. In the meantime, Lordship, the petitioner was also allowed to hold the search of headmaster, being the senior most officer. Thereafter, Lordship, page 25. Again, I have a letter to the district elementary education officer for promotion, seeking promotion, that is page 25. Letter dated 24/1/2014. Well, this is the letter again, Lordship, the petitioner is seeking. Well, prayer portion, Lordship. I therefore pray to your honor to be so kind as to look into my case sympathetically, so that necessary action may kindly be taken for my promotion as prayed for. Which act of your kindness I shall remain ever grateful. My Lord, page 26. This is the Lordship letter giving financial upgradation, wherein my name, Lordship, your Lordship will find. This is, although not the gradation list, your Lordship may skip this page, Lordship, 26. This is not the gradation list. My Lord, page 27. This is the letter of the district elementary education officer, Lordship, by which, Lordship, my application dated 24/1/2014 was forwarded to the Director of Elementary Education for giving, Lordship, necessary instruction to that effect, Lordship. May I read, Lordship, page 27. With reference to the subject cited, I have the honor to forward herewith the original prayer petition dated 24/1/2014 of Abdul Karim Chaudhary, is the petitioner of so-and-so school of this district, praying for inclusion his name in the gradation list of UP school teachers for promotion to the post of headmaster. It is to be mentioned here that at the time of promotion to the post of headmaster, Sri Abdul Karim Chaudhary, assistant teacher of so-and-so school of the school, has submitted his unwillingness to hold the post of headmaster, which is enclosed as Annexure A. My Lord, next page, Lordship, page 28. Lordship, this is the regular headmaster retired, and I have been allowed to hold the search of headmaster. This is the on in-charge basis, Lordship. Page 28. My Lord, page 29. Page 29 is the letter issued by the director to the district elementary education officer regarding promotion to the post of upper primary school, Lordship, relating to my case, Lordship. In enclosing here with the DO letter received from the Honorable Minister, PAC Department of Assam, dated so under reference. I am to request you to examine the matter and take necessary steps
Yes.
pertaining to inclusion of name of Mohammad Karim Chaudhary, assistant teacher of so-and-so school under your jurisdiction in the gradation list of assistant teacher as per rule. Thereafter, Lordship, the gradation list was prepared, that is page 30, Lordship. On 14/10/2014, your Lordship will see my name appear at serial number 2. In serial number 1, there is no name of the teacher, no STP teacher. That's why, although my name is figured at serial number 2, but I am in position number 1. Page 30. Abdul Karim Chaudhary. And your Lordship will find serial number 6, the name of the respondent number 5. Lakshmi De. My lord, this is the gradation list of different school, and name of Lakshmi De in the Lordship is a Hindi teacher. My lord, both the teacher from the same school, NMTC MB school, and respondent number 6 is NMTC MB school. Thereafter, Lordship, the impugn order was issued, that is page 36. Appointing the private respondent number 5, whose name, Lordship, appear at serial number 6. Page 36 is the impugn order by which the private respondent number 5 was promoted to the post of headmaster, ignoring the name of the petitioner.
Yes.
Well, that was a challenging this, Lordship, we file a writ petition. This writ petition. Now, Lordship, both the teacher, Lordship, has retired from the service. Well, not as the petitioner was entitled for the post of headmaster, Lordship, at least he should be given the benefit of
Both of them have retired.
well, not both the teacher retired.
When did respondent number 6 retire?
Well, not perhaps after
2018.
2018 or the
Then what is your prayer in this writ petition now?
My lord, if prayer in the writ petition is, Lordship, to set aside the impugn order, that is the promotion of the petitioner, respondent number 5, and and also direct second prayer, Lordship. Writ of mandamus shall not be issued directing the respondent authority, particularly the Director of Elementary Education, to provide for promotion of the petitioner to the post of headmaster. My lord, one was set aside the promotion of the respondent number 5, and second prayer was, Lordship, to issue a direction to the respondent to promote the petitioner to the post of headmaster. My lord, as the petitioner retired, Lordship, and the respondent number 5 also retired. At this stage, your Lordship may issue direction if your Lordship find that there is a merit of my case to provide me the notional benefit, Lordship.
Notional benefit like?
My lord, his service may be promoted for 1 day, or after that, Lordship, he will get the benefit of promotion, benefit of headmaster, Lordship. In the pension, Lordship, he will get some benefit.
Purely for pensioner benefits,
My lord,
not
can-
for area salary.
not any other, at least pensionary benefit, Lordship, he may.
Yes, Kaushik.
We have not filed any affidavit, but the private respondent affidavit, my lord. Their stand is that the petitioner himself deliberately handed over the charge to the respondent number 5, and he refused to take the responsibility of head teacher. And on that circumstances, my lord, the respondent number 5 was promoted.
But what is your instruction?
Our, we don't have any instruction, we have not filed the affidavit. At this stage, I think the petitioner has retired in the year 2015 itself. And the private respondent also has retired. And there is no prayer for notional benefit in the petition. So his prayer is directly for giving him the promotion. Now it is not possible.
That is the, but then how, on the merits, you'll have to give something.
From the gradation list, it is otherwise apparent that the petitioner was
Senior.
but annexure 3 of the repetition page.
That is admitting that I submitted an application expressing my unwillingness. Subsequently, that prayer was made to do that because I was fully cured. That was due to lordship ill health condition.
Now after the promotion, he showed his willingness.
This was the
Initially
application
he
of
writes page 20, he writes it to the authorities that he is not.
application was filed, that is page 21 in the year 2003. In 2004 itself, in the month of February, I submitted the application for withdrawal of that application.
That application, whether it was received by the concerned authority.
Well, that has been communicated. That is
That is not.
There is no-
communicated.
Page-
Oh, only
page
the-
24,
only-
Lordship.
Only your second application.
my lord, page 24, Lordship. This is the original copy. That is receipt. Office of the DO. My lord, page 23 is the type copy.
Hmm.
24 is the original. Left top side, Lordship.
This I can't understand.
My lord, this is a receipt 13/2/2004, office of the DO. Karimganj.
Is that correct, Mr. Kaushik?
That I have to verify.
Check up this page 24.
Yes, page 24, I've seen that. This signature seal, nothing is available. Only a date and office of the.
Signature is there. That has not been denied. My lord, in page 24, I have details, lordship, I have made details regarding this application of withdrawal.
But it was only after this 24/1/2014, which was issued, which was submitted by the petitioner, that it was forwarded to the director. After director wrote back to see that his name is included in accordance with the rules,
Yes.
then only the promotions was taken up.
Yes, thereafter the lordship gradation list prepared.
So practically, whatever it is, his withdrawal, he has taken it back.
Thereafter in 2014, he was given the charge.
He was given charge also.
That was also given.
Give him national promotion,
Lordship will find the
just for
affidavit of the private
just for the
respondent.
purpose of. That I'm not going into it. You can't rely on the respondent profiles affidavit.
My lord,
If at all you have to rely, you'll have to rely on your affidavit.
But to give him a notional benefit, the Lordship has to set aside that promotion order of the respondent. Because he is claiming that he should have been promoted in place of the private respondent. Now, if your Lordship will kindly have a look at page 2, the affidavit of the private. Page 2.
Oh,
The affidavit filed by the Srimati Lakshmi De.
yes.
May I read it, para 4. Before giving pairwise reply, response to the repetition, the petitioner respond number begs to state that the respond number 5 among other being selected and recommended by the district level selection committee for promotional post of headmaster of so and so with a prepaid a recommended list of not less than 27 assistant teachers got the promotion order on 25/3/2015 and joined the headmistress as on 22/4/2015. Therefore, the petitioner intentionally suppressed and the said fact while filing the writ petition, and instead of headmistress, he has shown the respond number 5 as Hindi language teacher. The petitioner was an in charge ad hoc of the said NCD who handed over the charge to the respond number 5 as headmistress newly appointed by so and so without any objection. And while handing over the charge, the petitioner retained with him 3 numbers of service book, amongst others, including his own service book, and these were handed over to the respond number 5 to the regularly promoted headmistress of the so and so.
Who is the respond number 5?
Respond number 5, Manoj, his name has been shown.
Yes, who is
SK
this?
SK Ghosh.
SK Ghosh.
SK.
Where is he? Okay,
I'll inform him.
we'll give him one chance.
I'll
After that,
inform him.
we'll-
Because otherwise,
we'll-
Manoj, he's challenging the appointment promotion.
Although we are challenging us that respondent number 5 has already retired.
He
That's
has
why-
retired, but then to give you the notional promotion, the
Yes,
his
the-
appointment order of the respond 5 has to be interfered with, isn't it?
Without interference, your lordship may direct lordship.
How come, Manoj, for
How?
the same post, Manoj?
Same post, 2 persons.
Any post, lordship, vacant post, they can
No.
accommodate.
No. But M. Khan, learned counsel for petition. Also has Mr. B. Kaushik, learned standing counsel,
Elementary.
elementary education department, staff. Non-appearance for the respond number 5. This is the matter of the summer vacation. In the event, the respond number 5 is not represented on the next retrievable date, this case shall proceed ex parte against respondent 5.
Can it be on Tuesday, lordship? Yeah.
What?
Can it be on Tuesday, lordship?
Tuesday, the-
27. Matter has already here, lordship.
It's a motion week,
But this matter will not take time because your lordship has
Only
already.
reopen.
30.
My lord. Obliged.
51 to 54 of supplementary.
What is this? Top of the list. What? 2031.
Yeah, please, your lordship. Lordship, in item number 53, lordship, there is WPC number 5906, 2013, lordship.
Hmm.
In that case, I am respondent number 15, lordship. And copy of the writ petition has not been served. Writ petition.
Why are you mentioning this at this stage? 2013 matter.
2013 matter, it was, lordship, it is not known to us. When it was come with tag matter, as a tag matter, lordship, then only I have verified and found that it is not served.
Who appears for the petition in item 53?
I appear for the respondent,
Private respondent.
private respondent. This
Lordship,
matter
I'm
was actually
appearing for
heard.
5906. The petitioner 125, lordship, for 125.
5906.
5906.
You're appearing on behalf of the petitioners.
Lordship, 5906,
Now,
I'm
this,
appearing.
counsel is saying that he has not received a copy of the writ petition.
Lordship, in this matter, long,
Item
Okay.
that is 54, lordship, it is,
Not 53.
it is 54, writ petition number. No, lordship. 53, it is 5906 read petition number.
Are you sure about which writ
Yes,
petition you are
yes,
appealing?
Lordship. 5906. Lordship will find in the office note 16/6/2014 and thereafter 5/2/2015.
16/6?
16/6/2014. There is an office note. Neither Eddie nor unserved notice has been returned back from respondent number 6, 9, 10, 11, 15, 16, 17, and 20.
And they are appearing in other case.
But in any case, you are appearing, isn't it?
My lord, all these respondents are here in our
Lordship,
cases, my lord.
copy of the writ petition has been not served, Lordship. Well, I gone through the record. I have examined from the court's record. Then I found that in that case, I was already as respondent number 15, Lordship.
You serve him a copy then.
Lordship, in this matter, my senior is appearing. Lordship, he is now enrolled as the senior government advocate. I'm appearing on his behalf, Lord. My name is not reflected in the cause list. I'm
Item
appearing on his
A3.
Who's your senior?
DK Sharma, Lord.
No, he can't appear in this. writ
Lordship, he
petition.
can't appear. I'm appearing on his behalf, Lordship. He can't appear. But this is a whole matter. I'm not sure about the copies. Lordship has been filed long back.
This is the problem. Now, we don't have a petitioner's counsel also, isn't it? Are you not appearing?
Lordship,
Are you appearing?
I'm appearing on instruction, Lordship. For DK Sharma, Lordship. He can't appear, Lordship, in this matter.
Huh, he can't appear.
Lordship.
Are you appearing on his behalf?
Lordship.
So he's appearing by way of proxy.
Lordship. Lordship,
How
since
can he
his name
appear?
is
How can he
name is
appear again?
reflected, Lordship, that's why I'm appearing on his behalf.
He's in the government panel.
Lordship, he's in the government.
Then how can he appear against state of Assam?
No,
He
he's
will
not, I
appear,
think he's not appearing. Earlier, he
appearing,
was the,
Lordship.
he was
He
the
was the
petitioner,
counsel.
now he has been appointed as a
State
additional
counsel.
senior government advocate.
Ah.
That's why, my lord, this matter, I'll tell my lord what has happened. This matter was taken up by this court. Not by this court, by another court, bench two. Virtually this matter, I don't know, this matter has become infected. 2 points that was raised. One point was that whatever prayer they sought for, my lord, that particular nothing remains in that prayer. Secondly, there is some disputed question of fact. The indication of the court being a disputed question of fact, how a writ court will interfere, that's what the court said. So the matter was kept today. That was the situation of the case, my lord. It was, I think, is court number 10, the matter was taken up. Day before yesterday, man. Day before yesterday, it was taken up. Top of the list it came. So court said we'll take up. So what was the prayer that was made? I pointed out before the court that virtually it has become infected. Because they were saying for the post of inspector of school, B.Ed is compulsory. They relied on judgment of division bench. That judgment, my lord, division bench was reviewed. I went for review. And the position remained for the post of inspector, B.Ed is not required. That's the whole grievance. How an appointment has been made because they doesn't have the requisite qualification. That has been reviewed. Recently, it has been reviewed saying no. That particular, then so what remains? That's a prayer, kindly see the prayer. That's what the court indicated when the matter was taken up. Second, what they have raised is all disputed question of facts. Court said whether a writ court can look into it when there is a question, a disputed question of facts. So that's why the matter was fixed today.
Yes, Bhuyan.
My lord, with all respect to my respected senior friend, my lord, the contention which has been raised regarding the B.Ed degree, my lord, when we filed the petition, my lord, on that day, my lord, that was our contention because the law was well settled. I can say, my lord, that an order had been passed by the Honorable Division Bench of this Honorable Court, my lord, that as the, my lord, B.Ed degree for the Deputy Inspector of School post is required, then why not for the Inspector of Schools, my lord? Some clarification was given on the strength of an affidavit filed by the, my lord, Secondary Education Department. Then, my lord, off late, my lord, when this private respondent realized, my lord, that may cause some hindrance to their appointment, my lord, they had come up with a review application, my lord, before this Honorable Court. And the Division Bench of this Honorable Court has clarified that as on the date of the advertisement, the requirement of the rule is the B.Ed, no requirement of B.Ed for the inspector of school, so that cannot be the basis for my lord challenge. So that was the clarification made. But my lord, the other issues which we have raised in this petition, my lord, those need some examination by my lordships, my lord. After hearing by my lordships, my lord, if found that we do not have any case, then we have to face the consequences, my lord. But hearing is required, my lord. On the
I think
go that,
that's-
my lord,
I
on
think
the
my
go.
learned I'm sorry to say, my lord, that
My-
was not the indication which was given by division bench.
My
The
lord,
affidavit, the commissioner,
my
on
lord.
the basis of the affidavit by commissioner, which was placed earlier to division bench. My lord, that was totally either the state has not pointed out what was the affidavit, so they passed an order. So,
They
but
don't have an
subsequently, we came to know, we realized that the affidavit supports us. We came to the court. By way, that day we moved. Yes, the commissioner has filed an affidavit saying for the post of inspector is not required. So court clarified. So what remains? What is his prayer?
Well-
His prayer is for the post of inspector as per the earlier order of a division bench that B.Ed is required. That is reviewed.
My lord,
Reviewed. So what is his prayer?
Review order?
Yes, what?
my lord,
kindly see the review order.
my lord,
What
may I
remains?
pray?
Nothing, my lord.
With the review order?
Kindly see the review order of this court. See the review order.
It must be an affidavit.
What remains for adjudication, my lord? Kindly see.
Our division bench order.
First, before going to the review order, kindly see what is the prayer they have made. See, my lord, the prayer.
In WBC?
In WPC
51.
5752. 5752. Kindly see the prayer. What is the prayer? 32A. Kindly see 32A. Got it, lordship?
Yes.
So cause an appropriate detail order direction should not be issued. Direct to respond to immediately cancel appointment or respond number 6 to respond number 21 and issue a press advertisement mentioning the proper qualifications as directed by the Honorable Court in judgment dated 26/2013 passed in WPC for appointment to the 16 number of post of IS and his equivalent post to initiate a fresh selection appointment process for the above post and after cause so and so, your lordship may be pleased so and so. So what they are saying, my lord, that as per the order of the court. Now kindly see the order of the court. Kindly see the order of the court now.
Page?
Page order of the court is, my lord, I'll just tell you lordship what was the order of the court. At page 86, kindly see, my lord, 86. Kindly see 86. Kindly see 86. 26/2013. Challenge in the writ petition proposed is to propose appointment to the post of inspector of school out of candidates who do not possess BT B.Ed degree with qualification required for lower post in the department. Matter was considered earlier and time was given to respond to consider the matter. Accordingly, affidavit dated 6/6/2013 has been filed, which in substance accept the stand of the petitioner. In view of this stand taken in the affidavit dated 6/6/2013, filed by Commissioner Secretary Government of Assam Education Secondary Department that B.Ed BT degree is necessary for the post of inspector of school, writ petition disposed of with a direction that the appointment post of inspector of school may be made out of the candidate having such qualification. Now, because this stand of the affidavit 6/6/2013, my lord, will kindly see at page 72, kindly see the affidavit. Basing on that affidavit, an order was passed by the division bench. Kindly see at page 7, lordship got it?
Yes.
Kindly see paragraph 7. That the deponent begs to say duties and function of the assistant inspector of school are similar to that of deputy inspector of school, block elementary education officer. The assistant inspector of school are the inspecting officer in respect of the school under secondary education, while the deputy inspector of school, block elementary education officer are the inspecting officer in respect of school under elementary education. In view of the above facts, and circumstance, government is of the view, since the B.Ed. BT degree is essential for any officer having inspecting duty, the essentiality of B.Ed. degree in the cadre of assistant inspector school as prescribed in so and so does not appear to be unjustified. What their whole case is in respect of assistant inspector of school, you made BT B.Ed and also for promotion. But for a direct recruitment for inspector of school, there is no qualification as such BT B.Ed. That is why they have come to the court. Now, this is what the order was. But when the matter was placed, this affidavit, I think human being errors are being made. So this order was passed, that BT at page 86. Now kindly see 86 again. Kindly see 86 division bench order. Accordingly, affidavit dated 6/6/2013 has been filed within subject except this stand of the petition. It's not that except the stand of the petitioner, because stand of the petitioner was that if in assistant inspector of school, B.Ed is required, so why not inspector of school? That was negated. They said, no, it's not required. What are the duties? So now when we came to know, now the appointments are being made. So it was placed, they again came for division bench before a single bench. And that was the prayer which I have shown. That's an order of the division bench. Where he appeared, we came to know this is not actually, it should have been passed by division bench. So we file a review application. Now kindly see the review. Review was, my lord, the order was passed on 1/3/2023. See paragraph, my lord, at 16, paragraph 16. Paragraph 16. Into 17 will be, my lord. Lordship got it. Down below 17 page. At the bottom 17.
Yes.
Paragraph 16. We therefore modify or clarify the order dated 26/2013 to the extent prescription under rule as on date is requirement of BT B.Ed for the lower post of assistant inspector of school, but the same is not a necessary qualification for the higher post of inspector of school. This is crystal clear, my lord. So they modified the order that has been passed.
When was this order passed?
This was passed recent 1/3/2023. 1/3/2023. The order which was earlier that was reviewed. That is 26. Kindly see what was the first at page 4. Kindly see the first word. Page 4. This review petition is directed against the order dated 26/2013 passed in W and other connected writ petition. Kindly see. This is what they have modified the order. So what is a prayer they made in the writ petition? They relied on the judgment of revision bench, which was subsequently reviewed. That is why, my lord, when we pointed out before the learned single judge on the other day, they said, what remains in your case? What is your prayer? And my lord, we have been working for more than 10 years now, 2013, in pursuance of court's order. Now thereafter, 2013, 10, it's pending. We are, my lord, working in the department. And the prayer which they have sought, what remains in this prayer?
Yes, we
This
are
is what, my lord, that's exactly what is the case.
very clear.
Secondly, my lord has said there are other points. What other points? You raised certain allegation against all the private respondent. We disputed. That's what the observation of the learned single judge on the other day. That why? How the High Court under 226 go before a civil court. It's a matter of evidence. Go before a civil court. If you are so aggrieved, we have disputed. What is the stand of the government? Government has not said anything. They knew, my lord. So what is remains in this case? Nothing remains in this case. Prayer is very clear. Your lordship has seen what is a prayer they have made for. So I think your lordship can close it with a direction to them. Let them go before a civil court, if at all. I think this is very clear, my lord. Where is that direction given by the High Court in division bench? That inspector of school at that elementary is reviewed. That order has been reviewed by the coordinate bench. I could have very well understood my review would have been there. There is no review. Reviewed has been modified. And already this was heard, my lord. By coordinate bench, same bench, my lord, heard. So, my lord, the prayer is very clear, my lord, 32A, kindly see what is the prayer. Again, at page 32A. What is 32A? Kindly see, my lord. Lordship, what is my lord? 32A. See that, my lord, what is the prayer? Yes, it is only with regard to prayer. How he can raise other points. That was the basic prayer we have made. Now he said, no, you go to other points.
My lord, I'm not on that. My lord, on the last occasion, unfortunately, I'm sorry, I was not here. There was a plea required that whether the pleas that we have taken would be sustainable and a writ court can go into it. That was the plea taken. What I find, my lord, subject to what my lord would say and objections of my seniors, my lord, there was empty number of anomalies in the whole selection process. There was forgery, there was cheating, there was, my lord, people, even the applications that were to be submitted through proper channel, that was not done. So, my lord, it was a clear case of pick and choose. That's why the anxiety, my lord. Now, what had happened, my lord, if my lord enters into those points, my lord will have to touch upon the merits of the case, my lord. My lord will have to go into each and every allegation. My lord, I'll have to take my lord through the pleading seat hall. So, in lieu of that, my lord will have the whole matter heard, my lord. That would be, my lord, proper, and my lord, it will not take much time, my lord. Understand, my lord's pressure today because there is lot many matters, but my lord, this matter requires a consideration because this is one case, my lord, wherein it's in the form of a scam, my lord. That's we allege, my lord, at least. My lord, that's our allegation. And from 2011, my lord, we have been doing this. It was heard on a number of occasions. Unfortunately, maybe for my default or for default of somebody, my lord, this could not be taken forward. But my lord, this has to be given a quietus today or tomorrow, my lord, whenever it's possible. So my lord will have it, my lord. Let the whole matter be heard. My friends on the other side will also have an opportunity to rebut. And then my lord can proceed further. Now the plea is, my lord, in the writ petition, there may not be certain pleas because it had not come out at that time when we filed the writ petition. But subsequently, my lord, we filed additional affidavits wherein all these particulars were brought. An honorable court, my lord, heard the matter. And the additional affidavits were directed to be given to each one of the respondents. It was given. Now they had a chance to rebut that. There are decisions of the Supreme Court that once the additional affidavit is given, my lord, subsequent plea is given, and they were given a chance to rebut, they cannot come back and say that the plea is not there in the writ petition. So this is, my lord, the entire gamut of the matter. If, my lord, today I understand, my lord, we have urgency, my lord, but I understand the pressure of the court also, my lord. My lord will have the matter on a date convenient to your lordship. My lord, let the whole merit be heard, my lord. This is my humble submission before your lordship. And my friends will also, my lord, be with me there. If my lord does not find anything there, fine, my lord. But there are issues, my lord, which touch upon the very root.
Problem. He wants adjournment very well. Let it be.
No, I'm joining. Today I can hear.
No. After vacation, let it be after vacation, my lord.
No, it's not because before the vacations, I don't want to clog my lord.
It's not that. What I'm saying that your lordship is saying, my friend, a lot of pressure is there. Other cases are there. So let it come after vacation, my lord. Very well. It may be fixed.
My lord, let it be on the opening, my lord. No problem, my lord.
After 25th of the next.
Sure.
After 20.
Subject to your lordship's convenience, my lord. My lord will fix a date. We'll finish off the matter.
My lord, after 20.
My lord will have the case on merits, my lord.
24th, my lord.
24th month, no problem, my lord.
Then this is consensus.
Consensus, my lord. Consensus.
Then I'll pass a short order
Lordship.
on request made by the learned counsel of the court.
Please,
Have you seen a copy of this review petition, review order?
Review order, my lord. No, my lord.
More detail.
My lord, I'll have a copy from them. I'll have a copy.
The order which you are relying on,
Lordship.
That has been reviewed.
No problem, my lord. That B.Ed degree will go, my lord, I've been told, but the other points will still remain. My lord is keeping it part heard, my lord has heard.
No, no, not part, I have not heard it.
Point now, part had got.
No, 2012, 11, 12 matter, that's why I said, my lord.
My lord,
Much obliged, your lordship.
your lordship is fixing a date.
24th.
24th, my lord, on merits, my lord. Much obliged.
Two of daily list motion.
But 24th is a Monday, my lord.
Yes.
Monday, lordship will have other motion matters also.
All the parties have left.
It would have been a better.
Yes, you are.
May I please, Lord? My lord, on this issue, my lord, one similar judgment, my lord, passed by this honorable court, my lord, I beg to, my lord, furnish before your lordship. Exactly regarding the same meeting of the DLC, my lord, same issue, my lord, next of kin was not submitted.
Now, on the last occasion, my lord, a record was called for, my lord. Original record of the.
My learned friend was there. My lord, my learned friend was there in this judgment, my lord. My lord, paragraph 3, my lord, kindly have a look. Paragraph 3. When the application was placed before the DLC of Hailakandi district on 5/10/2021, the same was rejected in as much as the next of kin certificate was not provided along with the said application. Then, my lord, paragraph 4. We reiterate the law of compassionate appointment that it is not a regular recruitment and the authorities are required to look into the issue with some compassion, as it is a claim for compassionate appointment and the only requirement of law is to make an inter-se comparison of the financial status of the respective applicant so that the words of the candidate is offered the appointment. Then paragraph C, my lord, 6, my lord. We hope and expect that the aforesaid observation is kept in mind by the DLC of Hailakandi district while considering the claim of the compassionate appointment. Accordingly, my lord, it was provided for reconsideration, my lord. Here, my lord, exactly, my lord, on the same, my lord, day, my lord, 5/10/2021, my claim was rejected, my lord, due to non-submission of the, my lord, next of kin, my lord. But I submitted, my lord, but it was Xerox, my lord. This is their claim, my lord. Even then, my lord, lordship kindly have a look, page 20, my lord, in my writ petition.
Yes.
Page 20, my lord, serial number, my lord, item 8, my lord, next of kin certificate, my lord. In the middle, my lord, serial number 1, 2, 3, 4, 5, 6, 7, and 8, my lord. Next of kin, my lord. Yes, my lord. But I admit, my lord, I lost the original next of kin. Therefore, my lord, I could not provide it, my lord, original one, my lord. By Xerox, my lord, always, my lord, I furnished it, my lord, and it is there, my lord, particulars also, my lord. And subsequently, I also, my lord, got, my lord, second, my lord, duplicate next of kin certificate also, my lord. So, my lord, similar order maybe, my lord.
My lord, in one part, my lord, it's similar, my lord, but here in this case, my lord, earlier it was rejected in the year 2012, my lord. And after 9 years, my lord, again it was placed, my lord. I don't know how it was placed.
My lord, lordship kindly will look page 48, my lord. Now, my lord, present one, my lord.
Let me submit.
My lord, why it is now?
Earlier it was
just one minute,
rejected in the
maybe
year
given.
2012.
My lord, page 48.
This is the second time after 9 years, my lord.
Kindly, I am showing.
And going through
Page
the order of
48,
the-
my lord, it was the, my lord, latest one, my lord, page, my lord, 48. My lord, it was rejected, my lord, on 5/10/2021, my lord, due to lack of, my lord, this next of kin certificate, my lord. Accordingly, I filed, my lord, writ petition, my lord, page, my lord, 49, my lord, next page, my lord. Page 49, my lord, in this writ petition, my lord, they, my lord, furnished the information first time, my lord, page 50, that, my lord, my claim was earlier also rejected, my lord. Page 50, my lord, accordingly, my lord, it was provided that the petitioner, first paragraph, last line, my lord, petitioner was also considered in the meeting held on 30 11/2012, my lord. Therefore, my lord, I have no other alternative. I had withdrawn the writ petition, my lord, page 51, my lord. Page 51, my lord, relevant portion, my lord, page 52, my lord.
Here also, in this case also, I appeared, my lord.
Yes,
So, my lord, second day, they had to withdraw, my lord, because first case, my lord, page 50, already the learned counsel for, standing counsel for the elementary education department has produced a record, and it was seen that the case of the petitioner was considered in the meeting held on 30/11/2012, my lord. And thereafter, on the next day, they withdrew, my lord.
yes, my lord. Because my lord, I have no other
Because
alternative.
because they have come to know that it was rejected, my lord. And now after 9 years, they come with another plea, my lord.
My lord, exactly, my lord. So kindly have a look, page, my lord, page 24, my lord. Page 24, my lord.
So, my lord, let me get the records from the original record.
My lord, my lord, here, my lord, I am admitting their case, my lord. Because I am admitting, my lord, their case, my lord, even I had not, my lord, submitted my next of kin, my lord. But I submitted Xerox, my lord, because original was lost, my lord. And subsequently, original second copy is also I have, my lord, obtained, my lord. So, my lord, this matter is very clear before your lordship, my lord. Next of kin certificate is not necessary, my lord. They may consider on merit, my lord. I have placed. Only, my lord, I am praying for. Yes, my lord. Reconsideration, my lord.
Consider the matter. Heard Mr. M. Barbuya, learned counsel for the petitioner. Also heard who appears for the department,
My lord.
G. Beku.
Yes.
Learned standing counsel,
One,
elementary education for 1,
3, my lord, and
1,
Five.
3, and
5.
5. And Mr. G. Beku, learned government advocate
For 2 and 4.
for respondents 2 and 4. Stop. The father of the petitioner, while serving as a regular assistant teacher in Bokrihar MB School, Hailakandi, died in harness on 10/8/2007. Stop. Thereafter, the petitioner made an application for appointment on compassionate grounds on 18/8/2007. Stop. The case of the petitioner, when was it first considered?
My lord, this is 30/12, my lord.
Was first considered.
Consider on 30/11/2012, my lord. Page 23, my lord.
Considered by the concerned DLC in its meeting held on 30/11/2012.
One more aspect, my lord, before, I'm sorry to interrupt, my lord. Annexure 4, this is after the first rejection, my lord. Whether that
That part I'm not going,
my lord.
on the ground that petitioner was less qualified. HSLC passed. Who is the petitioner's name?
My lord, it is named, my lord, page 23, my lord, Masuk Ahmad. I abstracted, my lord. Masuk Ahmed Borbuya, son of Litton.
After comma. The case of the petitioner was again placed before the concerned DLC,
On 5/10/2021.
and the DLC in its meeting held on 5/10/2021 rejected the case of the petitioner on the ground that the next of kin certificate has not been submitted along with the application. Stop. Para. Learned counsel for petitioner submits that at the relevant point of time, when the DLC considered the case of the petitioner on 5/10/2021, he had submitted only the photocopy of the next of kin certificate. Isn't it?
Yes.
No, not at all, my lord. I have,
My lord, in their, my lord, in their own particulars, my lord, page 20, my lord. Lordship, kindly have a look, my
That
lord.
is why this document was submitted after the DLC was.
No, page 20.
After the
It is
DLC
your
meeting.
particulars made against me, my lord. Page 20, my lord.
It was
Yes.
submitted after that DLC meeting was.
How it is, it can be, my lord.
There is there is no such date, my lord. How can we know when it was, whether it is genuine or not, my lord? Then I will have to verify, my lord. I have a strong objection, my lord, in this case.
Then cancel that line.
My lord, kindly, my lord, here in this case, my lord, I have judgment produced, my lord, here said, my lord, that, my lord, even, my lord, next of kin is not submitted, my lord.
Because, my lord, lordship may kindly pay us page 48, my lord.
Learned counsel for the petitioner. Placing reliance in the order dated. Seventeen one 2022. Passed by this court in WBC 217 of 2022. Submits that the case of the petitioner may be remanded back to the concerned DLC for reconsideration. In the order dated 17/1/2022, passed by this court in WBC 217 of 2022. This court had made an observation that the law of compassionate appointment is not a regular recruitment, and the authorities are required to look into the issue with some compassion, as it is a claim for compassionate appointment. And the only requirement of law is to make an inter-se comparison of the financial status of the respective applicants, so that the worst of the candidates is offered appointment. On that ground, the case of the petitioner was directed to be reconsidered by the DLC of the concerned district. After hearing learned counsel for the parties, this court is of the considered opinion that the ratio laid down in WBC number 217 of 2022 can be applied in the present case in hand. Inasmuch as the DLC, which held its meeting on 5/10/2021, rejected the case only on the ground that the next of kin certificate has not been produced, has not been submitted at the time of application. Accordingly, petitioner is directed to produce the next kin of certificate in origin
Along with the Xerox, my lord.
to the concerned authorities. And thereafter, his case shall be placed before the next immediate sitting of the concerned DLC for reconsideration of his case for appointment on compassionate grounds, with the aforesaid observations and directions with petitioner
In accordance with law, my lord.
In accordance with law.
and in accordance with law.
Deep law.
Three.
May I please, your lordship? My lord, it is the whims, my lord, and the discretion of the government, my lord, to make a policy. And my lord, if that policy, my lord, is arbitrary, unreasonable, or irrational, or my lord is unconstitutional, my lord, that policy can be, my lord, brought under the, my lord, discretion of my lordship's examination, my lord. Exactly, my lord, we, in this petition, my lord, we have challenged a policy of the government. My lord may be pleased to find that, my lord, notification is at page 54, my lord, this is an scheme government has recently formulated in the year 2017. That is the scheme for the compassionate family pension in lieu of compassionate appointment, in short called as the compassionate family pension scheme. My lord, what has happened earlier to this notification, my lordship knows and well, my lord, that if an incumbent dies in harness, my lord, while he was or in service, my lord, then that any of the member who is eligible and qualified from the family can apply for the particular post or service as per the discretion of the government. Now, my lord, by this policy, what they have done, they have completely revoked that policy and come up with a policy called Compassionate Family Pension Scheme. Now, my lord may be pleased to find that how this scheme is going to be implemented and who are entitled to the benefit. My lord may be pleased to, my lord, skip the few paragraph. In the paragraph, my lord, I am, my lord, paragraph 5.1, my lord, in the bottom of this policy, my lord. It is said, my lord, that the applicable definition of family of the employee dies in harness will be the definition of the family that is given in the Assam Service Pension Rules 1969 as amended from time to time. Now, my lord, can I, my lord, bring my lordship's kind attention to this, my lord, pension definition, my lord, family pension provided in the 1969 rules, my lord.
This one.
My lord, rule 143, my lord.
Page.
My lord, in this book, it is, my lord,
Okay.
rule
Yes,
one, yes,
yes,
my lord, yes,
I'm on 140.
143, my lord. Family definition. That the family, for the purpose of rules in this section, will include the following relatives of the officer: wife in the case of a male officer, husband in the case of a female officer, minor sons, and unmarried dependent daughters. Now, my lord, what they have, my lord, club this family part definition along with this compassionate family pension scheme. My lord, thereby what has happened, only in the family, my lord, when this serviceman dies, my lord, only those families are now entitled to the benefit of those scheme who falls within the category of the definition of this rule 143. Now, my lord, we the petitioner are the, my lord, an adult male member of our family. Now, in our family, my lord, there is no person who can, my lord, get the benefit under the definition of the family. Now, as a result, my lord, in the whole family, there we cannot, my lord, get the benefit under the scheme. That is one, my lord, embargo in us. So therefore, my lord, we have challenged the legality and validity of the as a whole notification of the scheme, that this is irrational, and the by way of this notification, my lord, they have made two classification of peoples, my lord. And the one person who have come within the definition and purview of this family, they will get, and those persons, my lord, who do not come under the purview of the definition of this family, they will be excluded. No benefit, my lord. So therefore, this is in violation of Article 14, as well as, my lord, other grounds we have also narrated in our petition, my lord, in detail. Today, my lord, I respectfully beg to submit, my lord, may be pleased to issue notice, my lord. This needs some, my lord, deliberation, if I can satisfy my lord, for a notice, my lord.
Here, there are a lot of families that are already getting the benefits of the compassionate family pension, my lords. So that is part of the scheme, my lords. Here in point 2, my lords, of this notification, my lords, it is mentioned the primary objective of the policy of the compassionate family appointment, that is page 54.2, lordship, has been to support the family income of the employee who dies in harness, who was the sole bread earner of the family as a stopgap arrangement, and if the family managed to sustain themselves for 3 years after the death of the employee, there was no ground for compassionate appointment. Lordship may go through page point. Now, yes, my lord. Point 3, why this notification was in the above background, it has been noticed that the existing compassionate appointment policy, my lord, the prior one, did not fully serve these objectives. And often their legal heirs fails to get an appointment immediately due to practical difficulties such as lack of education qualification by the legal heirs and non-availability of vacancy within the stipulated 5% of total vacancy, etc., my lord. There were certain hardships with the previous scheme, my lords, because of which this was introduced, my lords. And now there are a lot of families that are getting the benefit of this compassionate family pension, my lords. If this is set aside, my lords, what will happen to those families, my lords? These are the...
But my lord, as on date, my lord, when our father dies, my lord, that there is
These
no
things have
option
to be
left.
also considered, my lord.
Fine.
Lordship, 5.3, just read Bhuya.
My lord. When the employee dies before superannuation, the family pension equal to 100% of the last pay drawn by the deceased employee be paid for a period up to the date of deemed superannuation of the deceased employee. That is the date on which the employee would have superannuated and have been alive. This would compensate the loss of family income to a large extent and fulfill the requirement of compassionate conditions arising out of the death of the serving employees. That is correct, my lord. What they have done, that say, my lord, if a incumbent is 3 years service is left, he dies, my lord, then for that period of 3 years, this one of the member of this definition of the family, my lord, if my lord, wife survives, then wife will get the full salary, my lord, up to the 3 years. Now, my lord, here is the principle is well settled, my lord, that the no work, no pay. Now, here is a case, my lord, government is so compassionate that without any work, my lord, being rendered to the government, taxpayers' money is given to the, my lord, a widow without any work. Now, in the earlier occasion, my lord, there was a work, then only pay. Now, but this is a compassionate in such an extent, my lord, that you do not have to do any work and we will give the payment up to 3 years or 4 years till the service is left. Then, my lord, it is converted into the family pension scheme under the regular pension rules of 1969, my lord. Now, my lord, may kindly appreciate our case, my lord. In our family, this definition does not cover. We as an adult male member, in the earlier policy, my lord, we could have applied, we could have gotten job under the earlier policy. Now, by this definition, my lord, our family has been completely discarded. There is no scope.
Adult family means,
My lord,
adult member means,
my lord, adult member means, my lord, after the, because this,
you are adults.
we are adults, we are
but-
adults.
But not married.
No, my lord, we are the adult male members
Hmm.
and this definition of
But do
family
you have,
is,
if, see,
my
if-
lord,
if you are the petitioner
yes, my lord,
and an adult member of the family,
adult
deceased
member,
family,
exactly, my lord.
you'll have, be having your mother or your father.
No, my lord, because father dies, some in families, my lord, mother also dies and unmarried daughters are also not available. We are the single identity in the family, my lord, single member surviving, my lord. What will happen to those, my lord? This definition of 143 does not look into, my lord. For that, my lord, government can amend or modify the policy also, my lord. We are not saying that as a whole, it should be set aside, my lord. Government should also can take care of
Okay,
those.
you file your affidavit.
My lord.
Issue notice, but
But yeah, beyond the counsel for the petitioner. So, by this writ petition, the petitioners are challenging the legality and validity of the notification dated 14 September 2017 issued by the
My lord, it is the personnel finance establishment, a
by the
department.
finance within bracket establishment A close bracket department, formulating the scheme for compassionate family pension
My lord.
in lieu of compassionate appointment. In short, called as compassionate family pension
Additional.
within brackets
means custom of
CFP scheme.
Right.
Stop. On the ground that the adult family members
My lord,
of the deceased
deceased.
government servant are being deprived of getting the
Benefit of this scheme, my lord.
benefit of the scheme formulated under the notification dated 14 September 2017. Stop. Accordingly, issue notice. Nipara, huh? Mr. A. Chalial, and the Standing Council's Finance Department
Respond number 1 and 2, Lordship.
appears for the respond number
1 and 2.
1 and 2.
And for 3 and 4.
Secondary, Mr. S. SMPG still and the Standing Council.
I appear for
Secondary Education for respondents,
3 and 4.
3 and 4.
Here they have included elementary education, Lordship.
Hmm?
They have included commissioner secretary elementary education, Lordship.
Hmm.
Anyway, 3 and 4.
3 and 4.
I appear for 5, 7, 8, 9 and 10.
G. Bekul, Learning Government Advocate for respondents, 5,
7, 8, 9 and 10.
7, 8, 9, 10. And
And I'm appearing for the respondent 6, Lordship.
MS,
Yes, sir.
S. Sharma, Learning Standing Council,
PWD.
PWD Department and press for respondents. Notice on respondents are complete. Extra-
Yes, my lord, will
extra
serve
copy.
by.
Respondents are allowed to file their respective contract. Please the matter for this.
Obliged, highly obliged.
For.
Wait, please, Your Lordship. It's a matter relating to compassionate appointment, my lord.
Mm.
My lord, petitioner husband died in harness in the year 2013, and at the time of his death, he left behind the petitioner and his 5 years old minor daughter. Then the petitioner applied before the DLC, and the DLC recommended her name for grade 3 post. My lord, it's in the page
Petitioner is-
28. Page
petitioner is
28.
The wife,
Petitioner is the wife, my lord.
then. Where's the DLC recommended?
Page 30, my lord. Serial number 2.
When did you make your application?
I made my application 3 months after the death of the death of my husband on my
6/6/2013. 6/6/2013.
13, my lord. 3 months after the death of my husband. 5/6/2013.
Where's that application?
Application as page number 26, Annexure C.
Yes.
I addressed the inspector of schools, my lord. Then he forwarded the same to the DLC, and DLC accordingly recommend my name for assistant teacher, grade 3, my lord.
Yes.
My lord, after that, I waited and knocked every door possible, my lord. I went to the office of district and the state officials, but I got no any intimation from the state side that what happened to my actually SLC meeting, SLC minutes. Because I had a minor daughter of 5 years old, and then I was advised to reapply before the DLC, and accordingly, I again applied before the DLC in 2022, my lord. And it's annexed in the page number 39. But a DLC this time rejected my application, saying that I have already recommended, the DLC has already recommended.
Why should you reapply when the DLC recommended your case?
My lord, I had no any idea. Actually, I was in the dark, my lord. What happened to the SLC minutes of the meeting? My lord, after that, DLC gave an order, my lord, in the page number 39. You can see, my lord. The DLC directed the inspector of schools to examine the matter and take steps accordingly. After that, my lord, this is the important
Where's the DLC minutes?
DLC minus, my lord, page 39, my lord. Page 39, my name, serial number 1.
Yes.
After
This-
that, my lord,
This is correct.
yes, my lord, I got to know this is correct, my lord. I accept the
Then what-
same.
Then what?
Then, my lord, the inspector of schools wrote a letter, forwarded a letter to the director of secondary education, my lord. Kindly peruse the page number 42, my lord. Annexure F.
Yes.
May I read the important, relevant paragraph, my lord? This is the para number 2. May I read, my lord? In the connection, I am to state that the name of Srimati Zogo Burua Bora had been recommended by DLC meeting held for appointment on compassionate ground, Jorhat, on 25/11/2023 as assistant teacher. But no any further information from the state had been received. Subsequently, following the application of the applicant, the chairman DLC, Jorhat had taken into consideration her prayer and placed it before DLC meeting held on 21/2022. In prepared minutes of the meeting, the undersigned was asked to take necessary action as her name was recommended in the first meeting held on 25/11/2023. After receiving the letter, the undersecretary to the government Assam wrote one letter, my lord. It's in the page number 47, my lord. Page number 47, my lord. Letter from the undersecretary to the government Assam to the inspector of schools.
Page,
Yes, my lord. The relevant para I am reading.
page,
Yes, but and
page, page.
page 47, my lord. Annexure each.
Yes.
It is pertinent to mention herein that DLC Jorhat recommended dated 25/11/2013 in respect the petitioner was placed in the meeting SLC held on 26/8/2014. On that very day, my lord, I came to know that my name was actually rejected by SLC back in the year 2014, my lord. And along with the letter, they enclosed the minutes of the meeting dated 26/8/2014, my lord. My lord, that my rejection was at page number 60, my lord. SLC, page number 60, serial number 42, last column, my lord. Yes, back in the year 2014, the SLC rejected my candidature because of due to lack of required minimum percentage of marks in degree level, my lord. I came to know on that very specific day, my lord. Before that, I was not aware of that fact that my application was rejected by the SLC.
Then,
Yes, my lord, and
when
My lord,
when was this rejected?
it's 26/8/2014. It was rejected. But in this case, my prayer is very limited, my lord. Because of the reason I have cited one judgment, my lord, passed by this Honorable High Court. It is at page number 63. This is similar facts and circumstances. Similar SLC rejected the candidature of that very petitioner. And because of the same reason, my lord, page 63, may I read the relevant portion of the judgment, my lord? Having addressed to the first objection as above, the decision of SLC dated 26/8/2014, this is the same SLC, my lord, rejecting the claim of the petitioner on account of lack of minimum percentage of marks. Same reason, my lord. At a degree level may now be attended to. Schedule 2 of Assam Secondary Education Rules 2003 lays down the minimum education qualification for different categories of teachers. For the post of graduate teacher, minimum education qualification prescribed is 50% with B.Ed BT. It has been brought to the notice of the court that state government has taken a decision exempt teachers of state qualification for appointment as assistant teacher on compassionate ground. But this is the important observation that being the position rejecting the case of the petitioner on the ground of lack of required minimum percentage of marks at degree level may require reconsideration by SLC in the light of the above decision of the state of government. While reconsidering the case of the petitioner, SLC may examine whether the case of the petitioner can be considered against any other vacancy earmarked for compassionate appointment having regard to his or her qualification. But I have a very limited prayer, my lord. My prayer is also in line with that judgment. May I please, your lordship, it's page number 15, my lord, prayer portion.
Yes.
My prayer is to reconsider and recommend the case of the petitioner by the SLC to appoint me to the post of grade 3 or against any other vacancy, my lord, earmarked for appointment having regard to my qualification. But my contention is not that I need that grade 3 post, assistant teacher post, anything, but any post, my lord, in any department, if I am given an opportunity, because I am living a life of very destitution and starvation, my lord.
Yes.
Your lordship,
My
may
lord, the
please
only
guide me.
difficulty is that, my lord, it was rejected in the year 2014 and now it is 23, my lord.
My lord, I came to know in the year,
Petitioner was never communicated.
yes, my lord, in this letter it is already mentioned.
The undersecretary letter, where's that?
Yes, it's page number 42, my lord. It's clearly mentioned, my lord. No any further information from the state had been received.
Page number given, 42.
And I was with a legitimate expectation that, my lord, that my application would be accepted and I would get the job. And I had also one 5-year-old minor daughter, my lord.
The undersecretary,
Yes, undersecretary letter is
47.
Page 47, my lord.
He wrote only in the year 23/11/2022. That is a difficulty. You've been keeping quiet.
My lord, that is in response to the application submitted on 16/9/2022 by the. Let me obtain the instruction on whether it was communicated or not.
It was not communicated. The letter of the inspector of schools. Where's that letter?
The Inspector of Schools, my lord,
Page 42.
page 42, my lord.
Page 42.
My lord, I've gone through. No, I was misguided. That's why Can you dispose of it?
Next available SLC, let's go.
Heard Mr.
US Bora.
US Bora, then it comes for the petitioner, also heard Mr. Chisti, you are appearing?
No, yes, first my friend will appear for the chief secretary, and I am for 3-4.
J. Bekul, then it's government advocate for respond number 1.
5
One,
and
two,
6,
one.
7.
1, 2, 5, 6, 7.
1, 2,
No, no, one to apne ho.
No, chief secretary at
1,
Chief
2,
Secretary.
5 and 6.
1, 2, 5 and 6.
7,
And Mr. SMD Chisti, then the standing council,
3 and 4.
secondary education for respondents 3 and 4. 7 also.
Seven also-
7 also I appear, my lord.
Stop. Para. The husband of the petitioner while serving as assistant teacher. In which school?
My lord, school. Seolal Bayanwala High School, Majuli, Jorhat.
In Shiolal Bayanwala High School, Majuli,
Jorhat.
Jorhat. Died in harness. On 3/4/2013. Leaving behind the petitioner and her 5-year-old minor daughter. So, you are graduate,
She's graduate, my lord.
where's your degree?
Yeah, degree is at page number 20. She's graduate along with BEd degree also. DLN 20, 21 and page number 18.
What is the percentage?
Percentage is my lord, very, it's 39%, my lord.
Petitioner is a graduate. Along with
Along with DLN.
DLED degree. Stop. Accordingly, she made her application for appointment on compassionate grounds on 5/6/2013. Stop. Case of the petitioner was considered by the district level committee. Jorhat. And recommended the case. And recommended her case for appointment as assistant teacher within bracket grade 3 for the year 2013. Stop. Go after comma. As the petitioner received no information whether the state level committee had considered the case of the petitioner. She was running from pillar to post. And accordingly, she was again advised to make a fresh application, which the petitioner did on, when did you make your second application?
Let me check my lord.
Page
It's
number
21/1/2022, page number 35.
on. Page number 35 is the DLC.
No, it's a DLC dated, my lord. Application I didn't annex it.
Which the petitioner. Accordingly, petitioner met her second application for appointment on compassionate grounds, which was again placed before the district level committee, Johat. And the DLC in its meeting held on 21/1/2022. Made the observation that as the case of the petitioner, who is your name?
My name is at serial number 1, my lord.
As the case of the petitioner is earlier considered for assistant teacher for the year 2013 on the basis of availability of vacancy at the time by the DLC held on 11/9/2013. The Inspector of Schools Johat was directed to examine the case and take necessary steps accordingly. Stop. It was further observed that as the case of the petition is already recommended by the DLC held on 11/9/2013. Hence, her case cannot be recommended again. Stop. As no further steps were taken, despite the recommendations made by the DLC concerned, comma, petitioner made an application, correct,
Yes, my lord. Made an application on 2/9/2022
on 2/9/2022
before
the
the
Deputy
deputy
Commissioner,
commissioner. Yes.
Johat District. Requesting for a particular file number in connection with the appointment of compassionate grounds for the year 2013.
Yes, my lord.
Stop. The Inspector of Schools, JDC Johat, also wrote to the Director of Secondary Education Assam by communication dated 12/9/2022, stating that the petitioner had been recommended by the DLC in its meeting held on 25/11/2013 for appointment on compassionate grounds as assistant teacher. Stop. However, as no further information from the state has been received. No, cancel it. Subsequently, the petitioner made another application and her case was considered and placed in the DLC meeting held on 21/1/2022. Stop. In the said minutes, the Inspector of Schools was directed to take necessary action as the name of the petitioner was recommended in the first meeting held on 25/11/2013. Stop. While the matter rests thus, comma, draft petitioner again made an application to the Director of Secondary Education on 16/9/2022, requesting for the SLC minutes which was held on 25/11/2015 for appointment on competition grounds. Stop. Thereafter, comma, the Undersecretary to the Government of Assam, Department of School Education, by communication dated 23/11/2022, wrote to the Inspector of Schools, Johat, what is this? Stating that the case of the petitioner was placed in the meeting of the SLC, which held this meeting on 26/8/2014, and rejected her case due to lack of required minimum percentage of marks in degree level for the assistant teacher post. Stop. Para. It is the case of the petitioner that as her case was already recommended by the DLC in its meeting held on 25/11/2013, the state level committee should have considered her case. And if the petitioner was found to be lacking in percentage, to be lacking in
Required minimum percentage.
required minimum percentage of marks
Integrated.
for the post of assistant teacher, she could have been adjusted to any other post commensurate to her education qualification. Stop. After hearing learned counsel for the parties, comma, this court is also of the considered opinion that the state level committee in its minutes, in its meeting held on 26/8/2014 could have considered the case of the petition to any other grade 3 or grade 4 post. If the petitioner was found to be lacking in the required minimum percentage of marks for the post of assistant teacher. Stop. But in the view of the matter, comma, the matter is remanded back to the state level committee to reconsider the case of the petitioner to any other grade 3 or grade 4 posts commensurate to her educational qualification. And thereafter make appropriate recommendations in accordance with law in its next immediate sitting with the aforesaid observations and directions with petitions disposed.
Obligement.
5.
Well, this matter relates to provincialization of the service of the petitioner whose name was dropped at the time of provincialization due to that his name was not captured by the IS code. In similar circumstances, earlier lordship issued notice, my lord.
Yes.
Notice will be issued.
But Mr.
J. Sutia.
Jay Shutia, learned counsel for the petitioner. Issue notice. Mr. SMT Chisti, understanding counsel,
Secondary education. Okay.
1, 2, and 3. 4 by S. Bora earlier.
secondary education.
For the BTC, the party BT.
S. Bora
Accepts
appears.
Notice on behalf of respondents 1, 2, and 3. Who is responding for?
It's a BTC council, my lord.
Yes,
Their name
Lord.
is not shown in the cause list. In earlier occasion also.
S. Bora, my lord. Earlier he accept notice, my lord. This is the order, earlier order.
No, that's fine, but then whether she.
I'll serve him the copy, my lord.
Okay. Learned counsel for the petitioner is directly to serve a copy
To the standing
to
council
the
BTC.
learned standing council BTC with regard to respond number 4. Stop.
Right.
Respondents are allowed to file a contract, but list the matter after 4 weeks.
7 and 9 also
7 and 9
same,
same lordship.
same school, same.
Same order. 7 and 9.
Please, your lord, but I've got a very limited prayer before your lordship. My father died 2016. I have placed my application before the DLC. DLC said since my father has less than 3 years of service, so as per clause 1 of 2015 memorandum, I am not, my case cannot be considered. Now, my lord, I have annexed 15 cases passed by our Honorable High Court in a series of judgment, where my lord, Honorable High Court has said that 3 years is not to be ground to be rejected, my lord. So it is a compassionate matter.
When did your husband die?
My father died at 16/1/16.
Then when did you make?
Then I have filed an application, my lord.
When?
Immediately within 3 months, my lord.
Okay.
Then, my lord,
When was the DLC?
my lord, page 71, please come to page 71. Your lordship will find Bhavani Chetri, my lord, 71.
Yes.
Bhavani Chetri, claim has been rejected on the ground that Gov servant have not balanced minimum 3 years service as per the para 1 of the Gov OM dated 1/6/15. That is, death of the government servant is on 6/1/16. Usual date of the retirement is less employee of 31/8/18. That is less than 3 years of service.
When
That's-
did the DLC held this meeting?
This is it was held on I'm telling you my time. Just a minute. It was held on
28/6.
yes, but 28/6,
17.
17.
Correct.
Yes, exactly. So, my lord, our High Court has discarded that clause.
No,
It-
that issue is different.
No, that is 3 years.
That 3 years one is a different issue.
Yes.
First issue is why are you coming so late?
No, I have submitted my application. They are not forwarding it. I have not come late, man. I have submitted my application DLC.
Your case was rejected by the DLC.
DLC.
Then after that, what happened?
After that, my lord, since now new development has come and new law has come, considering my case,
So after that, you accepted the decision of the DLC.
I have not accepted. I have submitted application, my lord. They have not forwarded. They say we cannot send it.
What application?
My case should be reconsidered. They have not said. They said we cannot consider it. That is the case, my lord.
Have you approached this court?
Now that the new decision has come, my lord.
So you're keeping silent. After new decision comes, you wake up and then come before this court.
No,
How-
my lord,
how can this court
I
help you?
filed earlier one heat petition. That
What
was I withdrew, my lord.
What writ petition was filed?
To consider this matter, my lord. That I also annexed, my lord.
First hurdle is you'll have to overcome the delay.
Yes.
How do you overcome the delay?
My lord, delay is not on my part, my lord, because my father died 2016. Immediately I applied. They have considered the matter 2020.
17.
2007.
2017 it was considered. It was rejected.
It was
Because
rejected.
Your father did not have the minimum 3 years of qualifying.
I have no
service.
knowledge when they have rejected my petition. I must be communicated this matter. I
Now
have no
you're-
communication.
Now you are trying to improve your case.
No, no, no.
No.
No, there was no communication to me. I have no knowledge. I am a,
You have no
I am a,
knowledge.
I am,
This was, you
Yes.
have no knowledge.
I have no knowledge.
Suddenly the court passes the 3 years is not is violative of Article 14 of the
No,
Constitution.
but I was,
Then suddenly you
No, no,
you
no.
have knowledge of the DLC.
excuse me, well, that is subsequent development. Right? I was going on pursuing the matter. I did not get any communication. That's why it was delayed, not intention on my part, my lord. Not my
You
fault.
say you were not informed about the DLC.
After all, my lord, it is a compassionate appointment, my lord. Kindly consider all these things, my lord.
Mr. Biswas,
Yeah.
it is a compassionate appointment,
Yes,
but you'll have to, we'll have to consider the delay in you approaching this court also. See, one thing is DLC held this meeting in 2017.
yes.
You say you were not informed.
I was not communicated by them. Kindly
Then-
ask them to take
then
instruction
when
how the
this-
communication
when
was done
this
to me, my
court-
lord.
When this court passed the order saying that close one of the office memorandum dated 2017, I think. 2015
Was one of the.
is violative of Article 14 of the Constitution.
Yes,
Then suddenly you know that the DLC has rejected your case. You come with these judgments, all these separate judgments passed by this court.
yes. Then I have done.
These are cases where the petitioners have been vigilant and they've approached the court on time. But your case is after 2017, what were you doing till this year?
My lord, it's honestly submitted that I had no knowledge that what is the fate of my
When did
application.
you have knowledge of?
I am
this
still
DLC?
working in the school as an honorary teacher,
Where-
honorary
when
grateful
did you
employee,
have knowledge of the?
where my father died, man.
Mr. Biswas,
Yes,
when did you have knowledge of this DLC minute?
I have collected this matter from their office, my lord, from DC office,
When,
Tejpur.
when?
Well, it is not mentioned here, of course, my lord. It is not, I have collected this matter, my lord.
You drafted the petition, you should know the statements that you have made in the petition.
My petition was rejected, my lord, 2017.
That we know.
Yes,
I'm asking you, when did you know about when did you get the DLC minutes? Which you have annexed in this.
my lord, that of course I have not mentioned specifically when I received the information from the DLC. That of course I have not
The
mentioned.
issue is this.
Yes.
DLC rejected your case in 2017.
Exactly, my lord.
This court started passing orders in the year from 2022,
Yes, my lord.
correct?
Yes.
Then suddenly you wake up and come.
My lord, I,
Then you, in the court, you say you have no knowledge of the DLC minutes. Then you have approached this court.
my lord, I made two representations. One is 2016, one is 2022. I have annexed those two representations.
That doesn't matter. When did you
No,
get?
representation means to whatever the fate of my application.
When did you get this DLC minutes, which you have annexed in this?
My lord, before filing this, I have obtained this copy from the DLC,
When?
from the DLC from Tejpur, my lord. When the date, my lord.
You're avoiding my question.
No, when date, my lord, exactly I have not mentioned, but it is
File an additional affidavit stating when you received your DLC minutes.
obliged, my lord.
Otherwise, I'm rejecting this.
But it may come up within this week or after vacation.
Mr. A.C. Biswas, learned counsel for petitioner, prays for filing an additional affidavit to indicate when the petitioner received the minutes of the DLC, which held its meeting on where that minutes on
28/6/17.
28/6/2017. List the matter after the summer vacation.
Right.
May I please lordship? Lordship, it is a compassionate appointment.
Mm.
Petitioner's father was expired 31/7/2015
Mm.
while in service as assistant teacher of Pazar Bhanga High School, lordship. Being a eldest son, lordship, petitioners applied for compassionate appointment on 6/8/2015. 6/8/2015. But the DLC meeting dated 8/4/22, lordship, page 16.
Page 16.
Yes, lordship. Type copy, lordship.
Mm.
16 Lordship.
8/4/2022.
Yes, Lordship. The petitioner's application was rejected on the ground of that re-verify the proposal.
Hmm?
Re-verify the proposal and directed the inspector of schools to verify the proposal and submit the clear statement report in respect of the petitioner Lordship. Lordship, again, petitioner name place in the DLC meeting.
1 minute, 1 minute. Where's that observation of the DLC?
Page 16 Lordship. In below Lordship remarks.
Come to the original page.
Okay, Lordship. Page 23 Lordship.
Your name is a serial number.
Serial number Lordship, page 23. Serial number Lordship. Serial number 4 Lordship.
Serial number 4. Maidul,
Yes, Lordship.
what does it say?
Lordship, page 23 Lordship. Lordship, the applicant had applied within 1 year. Applicant passed HS with 63%. Applied for the post of assistant teacher. The DLC dated 8/4/22 discussed the proposal and decided to re-verify the proposal and directed the inspector of school to verify the proposal and submit the clear statement report in respect of the applicant petitioner in the prescribed format.
Then
Lordship, again, petitioner name placed in the DLC meeting 7/12/2022, but
Wow.
same was not considered on the ground of underage at the time of application. Lordship, page Lordship, page 26, vernacular 36 Lordship. Page 36 Lordship. Serial number 1 Lordship. In remarks, the DLC dated 7/12/22 discussed the proposal and could not consider the proposal of the applicant due to underage at the time of application.
how old were you when you met your application?
15 years, Lordship, 15 years ago. Lordship, similar candidates, Lordship, 23/12/22 DLC meeting, Lordship. Similar 4 candidates were considered who are underage at the time of file of application, Lordship. Lordship, page that is 42, Lordship. Same DLC, Lordship. Page 42.
Yes.
Lordship, serial number 1, serial number 3, serial numbers 8 and 9, Lordship, who are under age, Lordship. They are
Serial
considered
number
1, 3, 6, 8 and 9, Lordship.
Serial number, page 44.
Lordship, page 43, Lordship. 42 and 43, Lordship.
Serial number 1.
1, Lordship. Imran Hussain, Lordship.
Hmm.
Serial number 3, Lordship.
Yes, Beku. What
My
it
lord,
is?
my lord, in these cases, my lord, there is no such mention regarding their age, my lord,
Hmm?
in the remark column. Referring to those other 4 candidates. my lord.
Is
How
it
would the
mentioned that they are underage?
Yes, Lordship.
Serial numbers 1, it says he is a BA DLED. Obviously, he was a major.
Yeah, the date of application. to take
Lordship,
it.
date of application 12/8/2009.
Date of.
Date of birth, Lordship, 1/1/1994, Lordship.
अच्छा,
For-
date of date.
At Date of the death of the deceased employee, lordship, 15/7/2009, lordship.
2009.
Connectors are very not so clear. But
Hmm.
Yes, Begu
my lord,
seems to be underage.
let me obtain the instruction, my lord.
Look at the instructions. What MS?
P. Ghosh, lordship.
P. Ghosh,
Ghosh.
Learned Counsel for the petition. Mr. J. Bekul and Governor Advocate shall receive instructions. List. After? After the summary.
Lordship.
10.
Made, please, your lordship. Lordship, here, petitioner is the assistant teacher of LP school, my lord.
Mm.
And the district scrutiny committee recommended his name, page 18. LP school, my lord, 2 teachers is required to be provincialized. Page 18 is the recommendation of district scrutiny committee.
Mm.
Petitioner, my lord, Rafiqul Islam, lordship, what?
Mm.
Page 18.
Yes.
Then, my lord, page 22 is the website list. Only one teacher, my lord, that is the Zakir Hussain. He has been provincialized. And petitioner has not been provincialized. Page 22. This is website notification. my lord. Only one teacher of the school is provincialized. So petitioner has not been provincialized despite of recommendation by the district scrutiny committee. Now page 24, petitioner filed in appeal under section 14. That is pending, my lord. So my prayer that let the appeal may dispose of.
This is the issue that the provincialization matters before the.
Special court.
Your lordship also pass
Otherwise, my lord, may
appeal as per section 14, my lord. That has to be disposed of, my lord, to the secretary since recommended by the district scrutiny committee. So when grievance against the non-placing of case before the state level state scrutiny committee, appeal goes to secretary, my lord, government.
It should go to the Secretary School Education Department, isn't it?
government.
My lord, because the district scrutiny committee already recommended.
No, but you address it to the Secretary Elementary Education Department.
Elementary, my lord, a file will fetch, my lord, to the school education.
Heard Mr. M.R. Kandhakar, Learned Counsel for the petition. Also heard Mr. G. Beku, Learned Standing Counsel,
Elementary
Elementary Education. for the
respondent number 1,
respondents.
2,
1, 2,
4 and 5, my
4 and 5. And
Respondent number
Mr.
3.
G. Beku, Learned Government Advocate. For the respondent number 3. Stop. Well, the petitioner was appointed as assistant teacher. In which subject?
my lord, LP school not subject.
Okay. As assistant teacher on 11/11/2009 in Dikaltari, part 1,
Part 1.
Molapara LP School. To which post he joined on 14/11/2009. Stop. The District Scrutiny Committee consider the case of the petitioner along with one
Zakir Hussain.
district scrutiny committee recommended the case of the petitioner along with one recommended the case of the petitioner for provincialization as assistant teacher within bracket language along with one Zakir Hussain. Stop. However, comma, when the state scrutiny committee considered the matter, the name of the petitioner was dropped. And only the said Zakir Hussain was provincialized as assistant teacher,
Of
was, the name of the petitioner was provincialized against Dikaltari Part 1, Molabara LP School. Stop. Para being aggrieved. Petitioner also made an appeal under section 14 of the, that's so and so provincialization within bracket Act of 2017 in short. Before the Secretary to the Government of Assam Elementary Education Department on 23 to 2023. Stop. However, as the appeal is yet to be considered, petition is before this court. Stop. Para, after hearing learned counsel for the parties and on consideration of the materials available on the court, this writ petition is disposed of, directing the petitioner to file a fresh application, a fresh appeal under section 14 of the Act of 2017 before the Secretary School Education
Yeah.
Department within a period of
15 days.
15 days from today. Stop. Thereafter, comma, the Secretary School Education Department on receipt of the appeal shall consider the case of the petitioner after giving a personal hearing and thereafter dispose of the same in accordance with law within a period of
90 days.
2
2
months
months, my lord, 2 months.
from the date of receipt of a copy of the, from the date of receipt of the appeal with the aforesaid directions and observations with petitioners and disposal.
Appeal along with this order, my lord.
Oh, you filed an appeal,
I am
filed an appeal along with a certified true copy of this order.
11, implement of party.
My lord, we have to implement response number 14 as a response number 1 of the contempt case, my lord. Notice has already been served, my lord. That was also delivered during the intimation of this pending contempt case.
Who is the respondent?
He is Sri Narayan Kaur, IAS, Secretary to the Government of the Education and Elementary Department. Response number 14 of this IA. And will be the response number 1 of the contempt petition.
Will be response number 10, I think, of the contempt petition.
My lord,
You can't strike out response number 1.
my lord, response number 1, Sri Pritam Saikia, he is no more, my lord. He is from other department.
That has been changed to one Bijay Chowdhury, isn't it?
Vijaya Sudre, my lord. After passing of the order dated 24/5/2003, my lord, she has also been from other post, my lord. I have stated at page 9.
So we'll implement him as response number 10. That will be better for you.
My lord. It should be 1, my lord.
Why?
Your lordship may kindly turn to page 9.
of your,
My implement petition, IA 1702. And the last order, my lord,
page
of
9,
the contempt case, my lord,
page 9.
page 9, my lord. In a middle person, my lord. Accordingly, thereafter, on 24/5/2023, the contempt case C number has been 293/23 has been listed and order has been passed. That part, my lord. But on 24/5/2023, it was informed that the respondent opposite party number 10, that is Dr. Misha Vijaya Chaudhary, Secretary of the Government of Assam, to be implemented as contempt number 1 in contempt case was no longer the Secretary of the Government of Assam. While the matter was listed on 24/5/23, there is an also a order of this court, my lord, in contempt case.
No, in the contempt petition, you want to strike out the respondent number 1.
My lord,
Why?
he is no longer in that post,
But
my
is
lord.
he not supposed to answer to the contempt for the period he was holding charge?
My lord, the department has already informed, your lordship may kindly peruse the last order of the contempt case. my lord. Order dated 24/5/2023.
Yes, I want that. Liberty was granted to implead.
My lord.
That's
The-
all. So will you implead the present? How many respondents are there in the contempt?
In original contempt, there are 10, my lord. Wait a minute.
You don't know anything. How many respondents are there? 9.
9, my lord.
So we'll implead the present respondent 10. Because respondent 1 also will have to answer this contempt. What she was doing all these years when she was holding the office.
My lord. My lord.
But Mr.
D.
Bora Learned Counsel for the petition applicant. By this application, applicant is praying for impleement of Mr. Shri Narayan Konwar, IS, Secretary to the Government of Assam. Education within bracket Elementary Department, Dispur Guwahati -06, District Kamrup within bracket M Assam as party respondent number 10 in contempt case number 293 of 2021 on the ground that the respondent number 1 has been transferred out and the present proposed respondent is now has now taken over charge as the secretary. Stop. Accordingly, after considering the submission made by the learned counsel with the applicant, prayer for implementation is accordingly allowed. I is disposed in the contempt in view of the order passed today in IA number so and so. Let she get the full address be implemented as party respond number 10 in the present contempt petition.
And we have to take steps also.
Registry is directed to do the needful. Petitioner to take steps for service of notice on the newly implemented respond number 10 by registered post AD within 1 week.
And my lord, we have also correct the name of respondent contempt number 9, my lord. But we have verified the record. It has already been corrected by the registry.
Then
My pair, my lord, at 12 page.
that is not required. Then.
Obliged, my lord.
This the matter after 4 weeks.
Obliged.
13, admission.
Wait, please, your lordship. My lord will kindly produce order dated 12/6/2023.
12/6.
My lord.
Yes. You Sharma.
Yes, ma'am.
But this provincialization matters now, we are adjourning the.
Yes,
matter
and my lord, it is under 2011 Act, my lord.
Because the direction is already there.
Yeah.
We have a-
To place before a particular bench. I have in fact got to know about that, my lord. In fact, that if your lordship is pleased to place it before the
No,
concern.
no, I can't place it before the consent division bench because that has not been constituted yet.
Okay, okay, ma'am.
So I'll adjourn the matter up to the summer vacation.
In any case, they don't have the instruction, it seems. So let it come after summer vacation. My lord will give a date, my lord, kindly.
No, no date. Heard Mr.
D Chakravarti.
D. Chakravarti, learned counsel for the petition on request made by you Sharma, learned standing counsel.
For secondary.
Secondary resolution, list the matter up to the summer
After-
vacation. We'll see after that.
My lord, oblige.
15. In this case, Lordship, as per my lord's direction, I have received instruction. As per the instruction, it says that Lordship, government has given the grants in it, Lordship. Now, Lordship, the earlier judgment which was passed by the honorable court, Lordship, that was till today, no decision was taken. So government wants at least 1 month time to Lordship, take a decision, Lordship, by all the stakeholder, they will take a call. By University Authority as well as Lordship, the Government of Assam will sit and they will take a decision, Lordship, regarding that aspect. So, Lordship, 1 month time is required. My lord may kindly peruse the death instruction. For solving the issue and solving the problem, Lordship, both sides are, Lordship, have to sit, Lordship. Here in this case, Lordship, petitioner has paid the similar order which was passed earlier, Lordship. That order was mentioned in the letter, Lordship. And it was also annexed, Lordship, in page 26. Lordship. And in respect to earlier order, that no decision was taken by the authority. So, Lordship may give posted the matter in the Lordship 2nd week of August, Lordship. In the meantime, Lordship, all the parties will sit and they will take a decision, Lordship. And I have also
If
informed my-
decision is taken, well, I have no
I have
problem.
also
Heard Mr. K.K. Dev. K.K. Dev, learned counsel for the petitioner. Mr. K. Gogoi, learned standing counsel, higher education.
Lordship.
Submits that the respondents would be considering the case of the petitioner and therefore prays for prays for a month's time.
1 month's time, Lordship.
Praise allowed. List the matter again on.
So, 2nd week of August, then Lordship, it will be
16th August.
Lordship. My lord may keep the instructions as a part of the record also, Lordship. Today's instruction. Lordship.
No, then say like this, Mr. K. Google and standing counsel. Higher education. has produced a letter dated 20 June 2023, written by the Deputy Secretary to the Governor of some Higher Education Department, stating that the government has not taken any decision with regard to the directions passed in WBC number 6315/2016 and prays for a month's time to take a decision in the matter. Accordingly, list the matter on so and so. The letter dated 20th June 2023 is placed on record.
16, 17 and 18.
Pursuant to this honorable court's order regarding that matter inspection of a matter pharmacy institute matter. Lordship has directed the Director of Medical Education to constitute a committee and thereafter make an inspection and matter to place it. That matter we have already furnished in the form of an affidavit before this honorable court, but it is not in the court's record matter. There is certain matter translations are to be made matter in the particular annexure. For that matter, it has not been placed before this honorable court. So let it be matter next week matter along with the affidavit.
When did you file your affidavit?
I filed it yesterday. I have served copy to the other side.
May I pray, Lordship?
Yes.
May I pray, Lordship, on Monday, Lordship?
But Mr. K. Majumdar, learned counsel.
And in the meantime, Lordship, I also file my rejoinder today by you.
So let it be Wednesday matter. I will have to translate it matter, then I will have to correct.
My lord, I have some problem,
One
Lordship. I will be
annexure.
out of station, Lordship. I pray, Lordship, on Monday, if possible, Lordship. Because after Monday evening, I don't.
Then let us list it after the vacation.
Lordship,
Otherwise, my lord, the report is against the petitioner.
whatever may be, Lordship, I file my rejoinder, Lordship.
Yes,
I'll file it today itself, Lordship.
Mr. K. Gogoi, learned counsel for the learned standing council, health. Health Department submits that he has filed an affidavit.
Additional affidavit. no?
Additional
an
affidavit.
Additional affidavit on 21/6/2023, placing the report
Yeah.
of the
My lord, inspection carried out by the
Re-inspection committee, Lordship.
inspection carried out by the
inspection committee pursuant to honorable court's order dated 22/5/2023.
by the inspection committee. Mr. K. Majumdar, the counsel for petitioner, prays for a short time to enable him to file reply.
Today itself, Lordship, I will file my rejoinder.
Prays for this one day that. Prays for this time to file reply. Praise the Lord. After vacation, we'll have it then.
Last week of, Lordship,
Immediately.
July, Lordship, subject to convenience of this honorable court, Lordship. On 25th, Lordship,
25th.
Letter on 25th July.
I'll file my rejoinder today, Lordship.
Doesn't matter when you want to file it, you can file it. You can go and come back.
Lordship, I may be allowed to file the same. Obligement.
Just registry to verify and place the same on the board. Huh? Then after that, you say so and so wants to file affidavit in reply. Place for this time.
Much obliged, Lordship.
19 and 20.
May I appeal your worship? My lord, in this case, my lord, as per last order, my lord, record was called for, my lord. I said, records are called for today. Record of my lord selection was called for.
In this matter, record was called for on last date and accordingly record has come.
My lord, so my lord,
Here record with me, my lord.
my lord, so I pray for after vacation, my lord. Otherwise, my lord, matter is ready for disposal. Record has come, cleaning is complete.
On request made by Mr.
D. Gogoi,
D. Gogoi and the counsel for the petitioner, list the matter after the summary.
your record should be written.
Let him retain the reports. You retain the reports.
Yes. Hello, Ulas.
21.
Your lordship, this matter may be taken at to my senior legs in another court, your lord.
Who's your senior?
Mr. N. Bora.
Why can't you take up the matter Yes.
22. It keep going. That is after vacation, Lordship, 21. 21 is called. Let it come after vacation, Lordship.
Yes, after vacation.
After vacation, yes.
Item number 21.
Yes, 21 after vacation.
You, Mr.
N. Ahmed on behalf of N. Bor.
Heard Mr. N. Ahmed, learned counsel appearing on behalf of Mr. N. Bora, learned counsel for petitioner on request made by Assembly Chisti, learned standing counsel, secondary education. List the matter after the summer vacation.
22.
May I please, my lord. During the matter, my lord, the petitioner schools was established in the 1995 and thereafter applied for dash code prior to 2009 and 10. But the respondent has not given the dash code without any reason. And therefore the school ultimately dropped from provincial election. Madam. On the last occasion, SSA took time for instruction and to file affidavit.
Who appears for SSA?
People was the CA, Lordship.
B. Gogoi, madam. B. Gogoi.
I'm informed.
Lordship, Council Bigu is on legs in court number 10, but otherwise we have received their instruction. We'll file a.
What is your instruction?
Lordship, according to this, the instructions we have received pairwise, but it says that the name of the petitioner school, namely Paschim Par Madan Mohan VLP School under Education Block, South Karimganj, District Karimganj is not found on verification in the DICE database. It has not been found.
That's the whole reason for filing this writ petition.
Lordship.
that they have made an application for
Or dash code.
capturing on the dice code,
Yes, sir.
but you are not taking steps. Basically, that's the whole issue. Then
Lordship, whatever instructions, can it keep, let it come on record if possible. We file a affidavit based on that.
okay, heard Mr.
Ziu Ahmed.
G.U.
Ahmed.
Ahmed Learning Council. On request made by Mr.
M. Huya, Lordship.
Mr. M. Goyal, Learned Standing Council.
No, Lordship, on behalf of B. Gupta.
Learned Council appearing on behalf of Mr. V. Gogol, Learned Standing Council Assistant Substance that we have received instructions and prays for 2 weeks' time to file counter affidavit. Praise a lot. List the matter after the summer vacation.
Much obliged, Lord.
Oh,
P3.
Lordship has heard this matter on that day. Record has to be produced before the court, but before your Lordship looks into the record, I think my learned friend has argued the matter. Certain judgments were cited before the Sangmo court. I think your Lordship has looked into those judgments, which my learned friend has already supplied those judgments. Basically, my lord, those judgments says that the power of the judicial review to what extent? You cannot sit over the decision of a selection committee. That basically that's a judgment. And my lord, I just want to point out one thing before your Lordship looks into the records. Kindly, my lord, see my writ petition. See my writ petition at page 16.
60.
16.
Yes.
24, para 24. That the petitioner beg to submit a respondent authority have without following the criteria, guidelines and rule framed by Cotton University has prepared the select list for the post of Director Student Welfare in the Cotton University. Now what I've checked, I checked thereafter, my lord. I made a bit homework after going in and my learned friend it. There is one gazette notification. That's the Cotton University Act 2017. The Act of 2017. This is an act. The Cotton University, my lord, came into 2017, this act is, which they have framed. And kindly see, my lord, at page 34, section 34 of the act.
Yes.
34, selection committee. There shall be a selection committee for making recommendation to the Executive Council for appointment of professors, associate professor, assistant professor, registrar, finance officer, controller of examination, librarian, deputy registrar, deputy controller of examination, other officer of university, as may be provided for by the statute consisting of the following members. So, my lord, there is a selection committee for making recommendation to the Executive Council is the appointing authority. For this post, all the posts which is mentioned, this committee has been set up. And my lord will kindly see now 34(7), which we fall 34(7). The Executive Council shall constitute one or more committees for making recommendation to the Executive Council for appointment to other administrative posts. So what is this post, my lord? This post, Director of Students' Welfare, is an administrative post. So, and maybe kindly see further, my lord, the Executive Council shall constitute one or more committees for making recommendation to the Executive Council for appointment to other administrative posts and may prescribe by ordinance the procedure and methods to be followed in making such recommendation. So this is what, whether it is by virtue of the procedure to be followed by them, whether they said that there is an ordinance, by way of an ordinance, what are the procedure, method of the selecting, and thereafter recommendation to the executive council whether they have done or not. This is what my case is, my lord. If it is done, of course, my lord, then I leave it to the court. And of course, the judgments which my learned friend, this is that's admitted, my lord. I can't deny those judgments. Neither I can't distinguish. Those judgments are related to those of the register appointment of professor, associate professor. But there is one judgment. No judgment besides, my lord. There is no dispute about all those judgments. But your lordship has seen that there is an act. They have to follow that act. How the method of selection has to be done. Lordship will kindly see once again 34(7). So 34(7) maybe looked into it, my lord. May I read once again, my lord? The executive council shall constitute one or more committee for making recommendation to the executive council for appointment to the other administrative post and may prescribe by ordinance the procedure and method to be followed in making such recommendation. I don't know, maybe they have followed, there may be an ordinance in what manner selection will
You have
take.
an ordinance to this.
My lord, it has been followed. And my lord, what my learned senior is submitting, my lord, that is not there in the pleadings. That is not the case of the writ petitioner. And further, my lord, the writ petitioner having participated, she cannot now turn around and challenge the selection process.
My lord, I'll just give a reply to it. This is, of course, this is an act which a procedure has been laid down. This is nothing that act, my lord, whether it is law, this is an act which they have to follow. Your lordship of his own can ask, what is the procedure you have followed? My lord, one thing I'll show one more, my lord. This is one which I'm sure, my lord, they have not done it. I'm sure that there is no ordinance to it. Selection method also, I doubt in what manner. And my lord, if they does also, it has to, by an ordinance, they have to publish. By ordinance, they have to publish. What is a selection method? One judgment I found of the apex court by Krishna Iyer, my lord. 3 judges, your lordship will kindly see 3 judges. On all those judgments which have been checked is all 2 judges, my lord. Now this is 1983 SCC 418. Kindly see paragraph 17. Lordship, para 17. Very nicely written, my lord. I think that will really fit in our case. Para 17. Ruling of this court were cited before us to hammer home the point that the court should not substitute its judgment for that of academicians when the dispute relates to educational efforts. While there is no absolute ban, it is a rule of prudence that court should hesitate to dislodge decision of academic bodies. But university organs, for that matter, may authority in our system is bound by rule of law and cannot by a law unto itself. If the chancellor or any other authority lesser in level decides an academic matter or an educational question, the courts is hands off. But where a provision of law has to be read and understood, it is not fair to keep the court out. Now, my lord will kindly see in so and so case, what the court should have considered is whether the appointment made by chancellor has contravened any statutory or binding rule or ordinance. Lordship got it, my lord? And in doing so, the High Court should have shown due regard to the opinion expressed by the board and its recommendation on which the chancellor is acted. Further kindly see, my lord. The later decision cited before us broadly conform to the rule of caution surrounded in Govinda Rao, but to respect an authority is not to worship it unquestioning, since the bhakti cult is incept in the critical field of law. In short, while dealing with legal affairs which have an impact on academic bodies, the view of educational experts are entitled to great consideration, but not to exclusive wisdom. Now, this is what? Last finishing two line, my lord. Moreover, the present case is so simple, profound doctrine about academic autonomy have no place here. So it is exclusive wisdom which they have done it. Number, so my lord, I conclude that we don't dispute about the judgments, but their judgment, my lord, I said, my lord, you can do it. Those judgments, yes, are applicable, are not applicable in the present case because there is an act, statute clearly lays down that the procedure has to be followed and it is to be by an ordinance, which in the instant case, I'm sure that they have not done it. And this is absolutely an act, my lord. There is no question that I should plead this. And already it has been pleaded in paragraph 17. What more your lordship requests? Paragraph 20, 22. 22 already, 24 already pleaded, my lord. 24 is pleaded. Your lordship will kindly note down, 24 has been pleaded of my writ petition. 24. That the petitioner beg to submit, respondent authority have, without following the criteria, guidelines and rule framed by Cotton University, has prepared the select list for the post welfare. So what more, my lord? They have not followed. And this judgment makes it very clear. That's my submission before Lord. So ultimate prayer is that my let your lordship will interfere with the selection which they have done, because it's not done in accordance with the act. And accordingly, my lordship says an interim order that will subject to the outcome of the writ petition. If it is allowed, my lord. That's my submission before your lord. Yes. I'm closing my argument, my lord. Your lordship will kindly look into the record and see if it is done by an ordinance, if the selection has taken place, my lord, then of course, my lord. Wow. My lord, your lordship will just excuse me, my lord. I have one top of the list in one matter. They will remain, my lord.
Ordinance part is made, I'll read 34(7) once again, my lord. Executive Council shall constitute one or more committees for making recommendations to the Executive Council for appointment to other administrative posts, and may, the word here is may prescribe by ordinance the procedure and methods to be followed in making such recommendation. It is not mandated that an ordinance has to be passed to prescribe the procedure. But we have passed the first statutes of the Cotton University. And I have only one copy. Yes, my lord. Here, my lord, Director of Students Affairs. Huh? Right. Director of Students Welfare, my lord. It is, the term is prescribed, condition of service is prescribed, powers and duties, my lord, and mode of appointment. This is the flat limits.
You don't have a spare copy?
No, my lord, I got it at home. Only one, I'll give this one.
Yes.
My lord, so that is there in the first statutes of the university.
Yes.
And the composition of the
selection committees, my lord, that is prescribed in 34.1. That is why I was on 34.1, my lord. 34.1 says, my lord, there shall be a selection committee for making recommendation to Executive Council for appointment of professors, so and so, my lord, consisting of the following members. 1, Vice Chancellor as chairman. 2, the 3 persons not holding any office of profit under the university, of whom 1 to be nominated by the Chancellor, who is the Governor of Assam, 1 to be nominated by the Executive Council, and the other to be nominated by the Academic Council. The registrar shall be the member secretary. My lord, I have the records with me here, my lord. I also have an email from the registrar, my lord, about the composition of the selection committee, described because the order of their composition, my lord, it does not describe who the persons are. That first page is the email, my lord. It says, with reference, I would like to state that the selection committee of the Director of Students' Welfare was as follows: Professor B.C. Goswami, Vice Chancellor of the University as Chairman, D.K. Das, Registrar of Cotton University as Member Secretary, Professor Gautam Borua, Director IIT and former Director IIT Guwahati, nominated from the Executive Council. 4, Ranjit Kumar Devagoswamy, former Professor Tezpur University, nominated member from Academic Council. 5, Professor Tarun Chandra Sharma, former Professor of Guwahati University, nominated by the Honorable Governor of Assam. Governor is the Chancellor. So this is the composition. Thereafter, my lord, the records will reveal as to how the selection was made. My lord, the first would be the advertisement. Thereafter, that advertisement they have already annexed, my lord. Then, my lord, is a order for constitution of the composition of the selection committee. These are the members there, my lord. That is the 1st of September 2020. The others, those marks, my lord, green papers, my lord, are the individual marking sheets of each of the individual members of the selection committee. The yellow page, my lord, is the average of the marks secured. All the members, my lord, gave less marks to the petitioner. She, in fact, came out 3rd in the selection. In order of merit, she was 3rd. The private respondent secured the
green one is the,
my lord, green one are the individual marking sheets. Lordship will see the signatures below. These are the individual marking sheets. And the yellow page, my lord, all the 5 members, the yellow page is the, my lord, average of the marks of all the selection committee members. Here, Lordship will see it's divided by 5. That is the total marks divided by 5 to come to the, my lord, because there were 5 members. The writ petitioners secured the 3rd highest, private respondent the highest marks, and there is another person in between. There were a total of 5 candidates.
writ petitioner is,
Writ petitioner is, my lord, Nirupama Bhattacharjee, and the selected candidate is Prashanta Sharma.
yes.
So and this recommendation, my lord, was accepted by the Executive Council. Thereafter, my lord, there is a recommendation, my lord, the selection committee.
Where is the recommendation?
That page just below that, my lord, below or above, my lord. Not the full, there's one form kind of, my lord. One white page, my lord, yes. And after that is the resolution.
One is.
Of all the selection committee members, my lord, they gave less marks to the risk petitioner compared to the private respondent, showing that the private respondent is more suitable to the university under all the headings.
Is the recommendation.
And my lord, the executive council approved the selection, my lord. That resolution is also there. Resolution is towards the, what my lord, all three, my lord. Controller of examinations, my lord, the director of students welfare and another post. So the entire process was followed. And my lord, insofar as the judgment relied on by my learned senior, my lord, just before the paragraph 17 was read, my lord, but before that, my lord, what was the basis of this is in paragraph 16 of the judgment. This is JP Kulashestra. Well, if my lord comes to para 16, why the Supreme Court was constrained to observe as such. In the instant case, Dr. So-and-so and Sri so-and-so did not fill the bill, their marks being below 54% in master's degree examination. We have earlier held that power to relax as the ordinance now runs, insofar as high second class is concerned, does not exist. Inevitably, appointment of 3 respondents violate the ordinance and are therefore illegal. My lord, this is why they got below 54% marks, but they were selected. That is why the Supreme Court observed, my lord, that the wisdom, it cannot go against the rules. But the judgments which I have relied on, my lord, if my lord once comes to the set of judgments which I have given, my lord. But before that, my lord, the contention of the writ petitioner, my lord, as I understand, first of all, my lord, she challenged this selection on the basis of allegation of bias. That was her statement. Lordship had gone through the other day. She alleged that the selection committee members were biased insofar as one of the selection committee members was a relative of the selected candidate. We filed our affidavit in objection denying it, saying that this is an omnibus statement. There was no specific allegation of who is the relative, and we have categorically stated that there is no relative. Thereafter, we have also alleged that she did not make any of them as party respondents. Thereafter, she comes up with the IA, my lord, to implead them as party respondents. But this honorable court did not allow it because there was no allegation specific against any of the selection committee members. Having failed there, my lord, she has come up with this new plea that there was a violation of the selection procedure. If, my lord, there is a violation of the selection procedure, then, my lord, she participated in the selection process, knowing fully well the procedure. She took a chance, my lord, and as she was not selected, she filed this writ petition. That is impermissible, my lord, in this set of judgments, my lord. If my lord may first come to the first one, my lord, the first flag, 1991 SCC 30, para 12 and 13, my lord. Para 12, my lord, it will thus appear from the that apart from the fact that the High Court had ruled out cases of 2 appointments in one, though their appointments are not assailable on the same ground, the court has also found that it is necessary to sit in appeal over the decision of the selection committee and embark upon deciding the relative merits of the candidates. it is needless to emphasize that it is not the function of the court to hear appeals over decision of a selection committee and to scrutinize the relative merits of candidates. Whenever a candidate is fit for a particular post or not has to be decided by the duly constituted selection committee, which has expertise on the subject. The court has no such expertise. The decision of the selection committee can be interfered with only on limited grounds such as illegality or patent material irregularity in the constitution of the selection committee or its procedure, vitiating the selection or proved mala fide. Here is proved mala fide, affecting the selection. It is not disputed, but so and so. But this is what this 1990 decision says. Then, my lord, the second flag, my lord, 1992 supplementary, my lord, para 7 and 8. Para 7, my lord, we'll first consider the second point. In the first place, it must be noted that the function of the selection committee is neither judicial nor adjudicatory. It is purely administrative. The High Court seems to be in error in stating that the selection committee ought to have given some reason for preferring Dr. So-and-so as against the other candidate. The selection has been made by assessment of relative merit of the rival candidates determined in the course of interview of the candidates possessing the required eligibility. There is no rule or regulation brought to our notice requiring the selection committee to record reasons. My lord, this is basically on that, my lord, and reiteration of the previous one, my lord, that the High Court cannot sit in appeal over, my lord. Thereafter, my lord, Vibhas Kumar, my lord, the third flag, para 14. When a selection committee recommends selection of a person, the same cannot be presumed to have been done in a mechanical manner in absence of any allegation of favoritism or bias. A presumption arises in regard to the correctness of the official act. The party who makes the allegation of bias or favoritism is required to prove the same. Here, my lord, insofar as an allegation in the writ petition, my lord, there is no proof. It's a mere allegation without even stating who was the relative or who was a person who acted in bias. My lord, next is 2010 8 SCC, the next flag, my lord. Here, my lord, it decides, it quotes all the previous judgments on that, my lord. Basavia, my lord, from para 21 to 38. But lordship, it is basically on the same line that the selection committee cannot be, my lord, the decision cannot be set an appeal by the High Court, my lord, and basically this, I'll not bother lordship with that, but those are the paragraphs. Then my lord may come to the next one, my. This is para 12, 17, and 18. This is 2016 Madras Institute, my lord. Para 12, my lord. The contention of the respondent number 1 that shortlisting of the candidates was done by few professors bypassing the director and chairman does not appear to be correct. From a perusal of the documents available on record, it appears that shortlisting of the candidates was done by the director in consultation with the chairman and also senior professors. Further, it appears that the committee constituted for the purpose of selection consists of eminent scientists, professors of economic studies and planning, and other members. The integrity of these members of the committee has not been doubted by the respondent writ petition. It is well settled that the decision of academic authorities about suitability of a candidate to be appointed as assistant professor in a research institute cannot normally be examined by a High Court in its writ jurisdiction. Having regard to the fact that the candidates so selected possess all the requisite qualifications and experience, therefore the appointment cannot be questioned on the ground of search. Now here it's the same case, my lord. All the selected candidate and others, they are eligible, my lord. Then para 17 and 18. My lord, para 17, in Manish Kumar Shahi versus State of Bihar, the court reiterated the principle laid down in the earlier judgments and observed. We agree with the High Court that after having taken part in the process of selection, knowing fully well that more than 19% of the marks have been earmarked for viva voce test, the petitioner is not entitled to challenge the criteria or process of selection. Surely, if the candidate's name had appeared in the merit list, he would not have even dreamed of challenging the selection. The petitioner invoked the jurisdiction of the High Court under Article 26 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. The conduct of the petitioner clearly disentitles him from questioning the selection, and the High Court did not commit any error in refusing to entertain the writ petition. 18, my lord, in Ramesh Chandra Shah versus Anil Joshi, recently a bench of this court, following the earlier decisions held as under, in view of the propositions laid down in the above noted judgments, it must be held that having taken part in the process of selection with full knowledge that the recruitment was being made under the general rules, the respondent had waived the right to question the advertisement or the methodology adopted by the board for making selection, and the learned single judge division bench committed grave errors. Well, the rest, Lordship knows, my lord, G. Sarana, Madan Lal, they are all on the same, that having participated, you cannot challenge. So here, my lord, the first leg of the submissions of the challenge in the writ petition was bias, which is not there, my lord. We have contradicted that, and she has not been able to make any specific allegation of bias. There is no member of the selection committee against whom bias is alleged, arraigned as a party respondent. There is no proof of the allegation of bias. My lord, the second part, which they have now come up with, is, my lord, the procedure was not followed. My lord, the procedure was followed to the T. The selection committee, Lordship has read in 34(1) of the Cotton University Act. The selection committee is constituted purely in accordance with 34(1). All the members are in accordance with 34(1). They are all eminent persons, my lord. The chancellor nominee is there, a former director of IIT Guwahati, presently director of IIIT Guwahati, a former professor of Guwahati University. They were, my lord, nominees of the Executive Council and the Academic Council. The Vice Chancellor himself and the registrar were there. My lord, the selection was proper. Now they have come up with the plea that the process was not followed. If the process was not followed, she waited for the results to be declared, and thereafter, having found that she is not selected, she has come out with this reputation. So that is clearly impermissible, my lord. That is the settled law. These judgments go to that. So on both counts, my lord, the writ petition is not at all maintainable, and it needs to be dismissed. Yes. My lord, the private respondent is here.
Lordship, I am from the respondent number 4, my lord.
Yeah, Mr.
A. Choudhury, my lord.
Yes.
Lordship, I'd like to adopt the submissions of Cotton University, my lord. We have also filed our affidavit in opposition, my lord, in a similar plan, my lord.
Any more? Any other respondents?
No, my lord. No, my lord.
You file your affidavit also?
Yes, my lord.
Yes. Any
My
reply?
lord, yet to only, my lord, my senior counsel has already, my lord, argued, my lord, only yet to that, my lord, section, my lord, 34(1), my lord, the selection committee consists of the, my lord, the list of the members in regard to the appointment of professor, readers, and, my lord, lecturer. And the post is for the, my lord, director of students' welfare, which is covered by, my lord, 34(7), my lord. The other is only that much of, my lord.
No, 34(1) also says other officers.
Other officers, my lord. Other officers.
Other officers, it says.
Other officers as may be provided for by the statutes.
34(7) says. May constitute
Other office also.
any more committees for making recommendation. And may prescribe by ordinance. It says may.
May prescribe, my lord.
Not, the first part of 34(7) is shall, second part is may.
That much, my lord.
But Mr. D. does the senior counsel assisted by
N. Sarkar.
L. Sarkar, then counsel for petitioner. Also heard Mr. P.T. Nair. Leonard,
A. Choudhury,
1 minute. Counsel,
respondent number 4.
Leonard counsel, oh no, who applies for higher education?
Higher education. Yeah. Higher. So K. Gogoi or Tahbildar, they appear, but not usually.
Can have A.R. Dabildar, A.R. Dabildar, he has got nothing to say.
My lord.
A.R. Dabildar, Leonard standing counsel, higher education, for respond number 1. Mr. P.T. Nair, Leonard counsel, appearing for respondents. 2 and 3.
2, 3, 5 and 6, my lord.
2, 3, 5 and 6. And Mr. A. Chowdhury. Learned council appearing for response number
4,
4.
4, my lord.
4. Hearing concluded. Just a minute. I'll retain this your
My-
reports for
my
some
lord.
time.
The records, my lord. Records lordship will retain.
Yeah, I'll retain.
My.
I'll retain the statutes. also.
My lord. Deeply obliged. Next one.
60 of supplementary leave admission.
Item 16. Make a mention.
My lord, can the matter may be taken up after sometime? He is on court number 7, my lord, senior counsel. My lord. Pharmacy council matter, my lord.
60.
Where's Gogol?
My lord, I have yesterday demonstrated before my lord as to how the discrimination is being meted to me. And the only reason for giving the other schools, colleges are that they just preferred a letter. My lord, if preferring a letter without any, my lord, requirement thereof, my lord, if they are giving, why can't they give it to me also? My lord? And the same problems is there with those colleges also. And in the letter, my lord, which is there, part of the records before my lord, nothing is written that we have got students are studying, so kindly give us. And my lord, from 2023, regularly given. There is no law in that. Nothing has been demonstrated here also. And the PCI, my lord, even for the current session, they have given us the permission. So I pray, my lord, that my lord will permit us to proceed to have that college working, my lord. Any inspection, whatever they require to do, let them go ahead with that.
Where's Gogol?
My friend is. If my lord can have the communication dated 15/5/23, it's a loose communication which was given by Mr. Gogoi, my lord. 15/5/2023. My lord will have the second last paragraph, my lord.
Yes.
Accordingly, the pharmacy institutes, excluding so-and-so, had submitted their application for academic session 2023 and subsequently granted NOC with the approval of the higher authority. As such, government has issued NOC to private pharmacy institutes on the basis of their application. If my lord can just turn 2 pages, my lord will find the application. My lord, here also, my lord, last but one paragraph. In view of the facts and circumstances, we would like to request your honor to be kind enough to grant permission NOC to our colleges to enable us to admit the intending students in first year courses of pharmacy from the session so and so onwards in the larger interest of the intending students. And so, my lord, this was only said, nothing else, nothing more was there, my lord. So in that view of the matter, my lord, I pray that your lordship would be pleased to, my lord, protect our interest.
Both side doesn't. ইয়াত পেৰাকেইটা নাহিলে দেখোন মেইন পেজে আহা নাই 57 Here we have filed one affidavit. Bringing to record the report, inspection report of the petitioner institute matter. Their lordship will find
When did you file the affidavit?
on 33/2023.
My lord, that affidavit, my lord would find,
It is the additional affidavit. It is.
my
filed
lord,
by-
page 49 onwards.
Yes, 49 on, page 49, my lord.
55 is the
Turning
relevant.
page 49.
54, ma'am.
Yes.
Lord, you may kindly turn to page 54 for a moment. Annexure A, 54. This is the report that was submitted by my lord, 3 members of the committee, my lord, who went for inspection. My lord, may I read it, my lord? We have the honor to inform you that we inspected the Alama T College of Pharmacy, Badarpur, Karimganj on 26th of November 2021. This is to inform you that after going through the detailed checklist laid down by the Pharmacy Council of India, we have formed a complete report and the details SIFC are attached herewith. Regarding the fulfillment of all the prerequisite norms laid down by the Pharmacy Council of India, there were few shortcomings, the details of which are mentioned in Annexure I and SIFC form of Pharmacy Council of India attached herewith. This is to inform you that after the inspection, all 3 member inspecting committee have come to a conclusion that we can recommend Alama TR College of Pharmacy, Badarpur, Karimganj to start the degree and diploma in pharmacy courses subject to fulfillment of all the shortcomings. In the next page, my lord, also will see, my lord, the format of Annexure 1. One, my lord, principal. The requirement, my lord, experience required is 1 PhD, 10 years out of which 5 years as assistant professor. Actual experience, my lord, available in that college is PhD with total experience of 7 years instead of 10 years. Out of which 4 years as assistant professor, 1 year, 7 months as associate professor, 1 year, 5 months as lecturer. So, my lord, even the principal, my lord, doesn't have the requisite qualification to hold that particular post. Now, my lord, at 2, B farm, 4 rooms with size of so and so. Here, my lord, available is only 2 rooms. That too not of the same, my lord, required size. Laboratory, my lord, 10 rooms with size of so and so. Available is only 8 rooms, out of which 5 are functional, 3 are under construction. Out of the 8 rooms, 2 rooms size so and so. Now, my lord, machine room, here, my lord, it should be 80 to 100 square meter, only 70 square meter room is available. Central instrument room, it should be 1, the area is specified, it is nil in the college. Same way, my lord, storeroom, 1 room with so and so, it is nil. Next 3, my lord, administrative area, office 1, establishment, office 2, academic confidential room. 1 room with 60 square meters. Here, my lord, 1 room with 25 square meters. Same, my lord, staff facilities, head of the department for B Farm course,
4 rooms with so and so, it is nil. Faculty room for D firm and B firm courses, 10 meters square multiplied by so and so, it will be one, they have only, my lord, one room with 70 square meter, requirement is 91. Same way, my lord, animal house, my lord, not available. Library, one room of 150 square meter. They have one room with 90 square meter. Museum not available. Auditorium not available. Girls common room, my lord, it is there, but the size is, my lord, not as per the prescribed norm. Boys hostel not available. Computer room for B firm courses, one room of 75 square meter. They have one room of 45 square meter. Library attendant, nil. Library staff is not there. My lord, these particular requirements are there, my lord.
But it says more or less fulfilled.
Yes, my lord. Subject to, the report says, my lord, subject to fulfillment of this condition, they can be granted. But even then, my lord, there is a condition, my lord, in the my lord, NOC that has been issued to the petitioner for the session, my lord, 2021, 22.
Let us see that one.
Yes. That they will, my lord, do the needful for meeting out this particular, my lord, lacunas.
NOC is dated.
44.
Yes. Lord, so we will see page 45. Page 45, my lord, NOC condition number 2. The institute shall fulfill all requirements with regard to physical infrastructure, clinical facility, and teaching facility as laid down by the government within 1 year from the date of issue of the NOC. Now, whether they have done this. Now, in this particular, regarding this particular clause, the present petitioner on the last occasion pointed out to the NOCs that we have issued to other, my lord, pharmacy institutions who have been initially issued that NOC was issued for a period of two years. 2021, 21, 22. They have now been issued for the next year onwards, my lord, 22 to 23 onwards. That, my lord, may have placed certain documents in that regard. There also same condition is there. I am not denying that, my lord. Probably, my lord, might be, my lord, they also do not fulfill the, my lord, the entire parameters fixed by the Pharmacy Council of India. But, my lord, in this regard, my lord, what I am praying from the very first day that this, I pray this honorable court will direct the respondent authority to at least consider, my lord, petitioner will submit one application. Let them consider within a period of 2 days, my lord. This honorable court is not the authority to decide whether NOC is to be given or not. These are technical issues. Let them decide, my lord. Let the matter be kept pending. Lord, we will fix it after the vacation. Let him approach my lord, why he is, my lord, signing off from approaching the honorable.
One submission before anything, my lord, falls from my lord.
When this report is very.
My lord, let my friend just place before my lord the requirement of law. Why one, my lord? I'll do it every year, my lord. My lord has seen the application submitted by the others. Nothing is there, just a prayer. Kindly allow us. They have been allowed. Why, my lord, this institution is being, my lord, discriminated
That is the, my
against?
lord, stand of the petitioner. Then, my lord, without fulfilling these conditions, also we cannot.
Fine. Then, my lord,
Go
how
ahead
have you
and-
how have you granted it? Let the inspection reports of all the other colleges be placed before my lord. My lord will make a comparison.
Yes, that I will place, my lord. That is the requirement. Why not?
But
Let us not go into
all this, my lord, only thing is, my lord will direct them.
Even I am saying, my
That
lord,
I'm
this-
not
there
saying,
is
my
nothing-
lord, will direct them that maintaining parity with the other colleges. Let this college also be considered within a week. My lord, let them consider and grant the necessary NOC, my lord. With the conditions maintaining parity with the other
Yes,
colleges.
so that's
That
I'm
much,
saying,
my lord, will direct.
Yes, my lord. Let it be, my lord. After 2 weeks, at least 2 weeks time may be given to us. We consider it, my lord. If required, we will place it before the honorable court. What is the harm, my lord? Lordship will
But
indicate,
because
my lord.
thing is, I
At least
wanted,
that parity will maybe there, my lord. Like
But
the
what you are submitting, what you are saying is he should make an application.
of course, my lord. Otherwise, also, if lordship says, my lord. At least, my lord. If some document is required,
my lord directs them maintaining parity with the other colleges. Let them also, my lord, consider the case of this college and pass appropriate orders granting us NOC. Because, my lord, if the NOC does not come,
granting us NOC is something, my lord, the authority will consider. But at least, my lord, until and unless he approaches, if certain, my lord, document is required or information is required, my lord, from whom the authority will ask, my
my
lord.
lord,
he will
they'll ask
refer to
me,
the
my lord.
court's order.
They'll ask me, I am there. I'm not running away anywhere, my lord.
Order may be there that he will cooperate.
I'll cooperate, my lord. if required.
No point, my lord, otherwise.
The problem is, my lord, there is something beyond this. That's why, my lord, the insistence why
Let
the
them put it
respondent.
in affidavit, my lord. Let the petitioner, my lord, he is fighting for such a long time.
Because, my lord, I am before my lord only on one point.
Future of the students at stake.
And my lord will say, PCI has granted me the permission this year also. That's the main institute, main organ and body.
One, my lord, judgment.
Let the government take
related to NOC. One judgment, my lord, 2023, 3 SCC 502. One observation is there of the Honorable Apex Court is Pharmacy Council of India versus Rajiv College of Pharmacy and others. Is regarding a moratorium period, my lord, whereby, my lord, the affiliations were stopped. But, my lord, while deciding this, my lord, the one observation has been made by the Apex Court at the end of the judgment. In general, my lord, not relating to this particular case. My lord, it's para 57. 2023, 3 SCC 502.
502.
My lord.
Where's the judgment?
Copy of the-
May I, my lord, give the copy? Para 57.
You don't have a copy?
My lord, actually, that last page is missing from my Xerox, my lord. I gave to my lord, they gave print out, my lord.
Which para?
Para 57, my lord. It is further to be noted, my lord. Found it, my lord. Para 57.
Oh, 502.
Page 502.
Yes.
It is further to be noted that the applicant seeking approval for DPharm and BPharm courses are required to be accompanied by a no objection certificate NOC from the state government and consent of affiliation from the affiliating body. Well, the affiliating body will be the university. While scrutinizing such applications, the council can always take into consideration various factors before deciding to allow or reject such application. Merely because an institute has a right to establish an educational institution does not mean that such an application has to be allowed. In a particular area, if there are more than sufficient number of institutions already existing, the Central Council can always take into consideration as to whether it is necessary or not to increase the number of institutions in such an area. However, a blanket prohibition on the establishment of pharmacy colleges cannot be imposed by executive resolution. But here, one more thing, my lord, Lordship may kindly see that new affiliation for the recent year, my lord. For a moment, one single page was here provided to this honorable court. And just I want to like to point out one thing on the decision part. One page was given. It's regarding, my lord, for the section 23-24.
By the
Yes.
PCI?
Yes.
PCI.
Yes. The decision part, Lordship may kindly see. BPharm grant approval for 2023-24 academic session for the conduct of 4th year of 100 admission for BPharm courses. Allow 100 admission in 2023-24 academic session in first year. The last approval of 22-23 academic session is restored and by notification dated 22-10-2022 read with 3/11/2022 instructed the institution to submit an affidavit. What is that affidavit? In view of above, it was decided to verify the said affidavit during the inspection process. So might be, my lord, they have given some undertaking that, my lord, whatever there is a loophole, my lord, they will, without that, or my lord, if NOC is not available, they will have this. This is something, my lord, a conditional, my lord, from first day onwards, my lord, a conditional, my lord, affiliations have been given.
Now, have
I
you
pointed
seen
out.
this para 57?
Yes, I'll answer to that. Para 57 pertains to a situation, my lord. I'll come to that, my lord. My lord will come to the first approval given to me, my lord. My lord would come to page 33, my lord. Sorry, my lord, page 28. What had happened, my lord, in the country, there was a moratorium given because there were mushrooming of colleges. But in the northeastern region, that is not applicable because we don't have colleges. My lord, we'll have 28. C, my lord, 2C. Moratorium for opening of new DPharm and BPharm institutions from 2021. Academic session is not applicable. My lord, that judgment is not applicable to the Northeastern region. Because, my lord, here the moratorium is not applicable. In other parts of the country where there is mushrooming growth, my lord reads that para 57 towards the bottom, my lord would find that, my lord. Secondly, my lord, my friends is only trying to delay the matter. My friend has referred to the conditions in my the first NOC. The same very condition is there in the first NOC given to the other colleges, who also, my lord, without NOC started off. Second NOC which was given to those colleges, my lord, from 20 to 23, you go on. Same condition with regard to fulfillment of physical, teaching, clinical. Within a year or two is also given. In my case, because I did not submit an application, they did not give it to me. They did not remove it. There is no further inspection made, my lord, after that in any of these colleges. Now we go up to the PCI, my lord. PCI, my lord, says, if my lord reads this, the bottom part of that paragraph which my friend has read, it says, in view of the above, it was decided to. My lord has got it.
Yes.
My lord will have the 3523. Just the last line of the first decision, my lord. In view of the above, it was decided to verify the said affidavit. During the inspection process of 23-24 academic session. So PCI will do that verification, my lord, not the state government. So PCI does not say that don't proceed before we do that inspection. PCI said, go ahead. First year, take 100. And for D Pharma, 60. And you go ahead. But we will consider that when we come for your inspections. Now, why, my lord, the state, who is to only look into whether my land is proper, the ownership is proper, land documents are, they are only to that extent, my lord. Rest is by the affiliating university and by the PCI. Affiliating university has no problem because it has already increased my stakes. Correspondingly, my lord, PCI has done it. 20-23, we could not get it because, my lord, we were not allowed to function. Now it has been restored and we have said, you go ahead. But because of this, my lord, condition therein in that page 44, that don't admit students, my lord, we are not being able to go ahead. I only want, my lord, to direct them to give me a parity following the other four institutes and this PCI's letter. Otherwise, my lord, if June goes, all these students will get admitted somewhere else. What will I do with my school college, my lord? This is a private institution. Nobody is going to compensate me for that. Self-finance institution. I only pray. My lord will monitor the issue. I'm not saying my lord will dispose of the matter. My lord will monitor the issue. But an interim direction, my lord also says, PCI says we will make the inspection. Let them do it, my lord, whenever they want to. But they don't bar my proceeding, my lord. My lord will not put a bar there, man. That's what the state government wants, man. That this institution should remain as such.
You'll have to cooperate with.
I'll cooperate whatever my lord required, but it should be within the parameters of law, man.
Heard Mr. Yukin Ireland, Senior Counsel, assisted by Mr.
MJ Kadir, my lord.
Learned Counsel for the petitioners. Also heard Mr. B. Gogoi, Learned Standing Counsel.
By the health department.
Health Department.
For 6, my lord, he is appearing.
Was it for pharmacy council? I am.
6 and 7.
I don't care.
For the respondents, 1, 2, and 3. No, 1, 2.
3, 4, and 5 also. 5 will look here. Affiliating university.
And Mr. K. Gogoi, Learned Standing Council or CGC?
CGC.
CGC for the
Pharmacy Council of India, Lord. Yes,
Respond number 6.
respond number 6. Stop. The petitioners before this court are aggrieved for non-issuance of NOC for the session 2023, 2022.
22-23 onwards.
From for the session 2022-2023 onwards. For admissions. In which course?
My lord, B farm and D farm.
For admissions in the B farm.
D
and
dot farm.
D
and
farm
D
courses.
courses.
Stop. The petitioners college was earlier issued NOC by
Page 44, my lord. Order dated 3/6.
This is an order or
No, it's a communication,
by
3/6/22.
communication dated 3/6/2022. For starting of degree of diploma in pharmacy courses. For the session 2020-2021 and 2021-2022. Subject to conditions laid down in the communication. Stop. The main grievance of the petitioner is that other institutions.
My lord, main grievance is that that same letter says no further admission for the session 2022.
Main
22.
grievance of the petitioner is that in the said communication dated 3rd June 2022,
22.
the it also stipulates where that no that
My lord, just after that 21-22, subject to the condition that no further admission for the session 22.
stipulates that
And thereafter.
subject to the condition that no further sub admission for the session 2022-2023
And thereafter.
and thereafter shall be made by the institute without government permission. Stop. The petitioner, the learned senior counsel for the petitioner submits that other institutions
Lordship.
have-
Who were similarly granted
who were similarly granted
NOC.
NOC were granted and have been granted the no objection certificates by communication dated 25/5/2022, correct?
Page 71, my lord.
Is it 68 or 71?
Was 68 also. 68 also. No, it will be 71, my lord. That is the 68 is the first one, my lord. Similar, then 71, my lord.
By communication dated
22-23, my lord.
2023 by granting NOC
From 22-23 session
for the
onwards. my lord.
session 2022-23 onwards. So it is submitted that as the petitioners college did not submit the application for grant of NOC, the state respondents have have not issued the NOC, and thereby the petitioners college is being deprived of taking admission for the session 2022-2023
Onwards.
Stop. Learned senior counsel for the petition has also produced a copy issued by the Pharmacy Council of India. What is this?
My lord, this is the permission, my lord.
Granting permission,
Permission, approval, my lord.
granting approval
Mm.
to the petitioners college
Mm.
for conducting 4th-year admissions, is it correct?
Your lordship.
For B Farm course
And
and D Farm.
4th-year admission for, my lord, for 4th-year admission for D farm, B farm course.
D Farm.
And
B
a
Farm
4th-year
course.
session, academic session for, my lord, 4th year for B farm, and also taking 100 admissions in 22-23, my lord.
Oh. for fourth year.
Academic
admissions
session.
In B Farm course.
Hmm.
And also taking admission for, and also taking for, and also granting permission for 100 admissions for the 2003-2024, correct?
Lordship. Then, my lord,
2023-2023.
and D Farm,
And D Farm.
the extension of approval up to 23-24 academic session for 60 admissions for D Farm course.
And for D Farm, approval was extended up to 2023-2024 academic session for 60 admissions in the D Farm course. Stop. He therefore submits that by maintaining parity with the other colleges that have been granted NOC,
Lord-
correct?
Lordship.
Petitioners college may be permitted to proceed with the admissions in terms of the approval given by the Pharmacy Council of India, within bracket, PCI. Stop. Mr. B. Gogoi, Learned Counsel for the for the Health Department, on the other hand, submits that unless an application is made by praying for NOC, the state respondents would not be in a position to grant NOC. Stop. As the other institutions had already made the applications, and it was on this ground that the NOC was issued to the other institutions for admissions to the 2023-2024 session. Stop.
2022, 23
2022-2023 session
onwards.
onwards. Stop. I'm not disposing of this matter.
Lordship, Madam will keep it.
Let it be. After hearing learned counsel for the petitioners.
My lord will also record one submission that my submission, my lord, there is no provision that every year the
Learned Senior counsel also submit that there's no provision under the law. That every year, the
call it
the
Institution.
institutions would have to apply for NOC from the state government.
it's a PCI which grants the approval
And
every year.
and it is the PCI who grants the approval.
Every year.
Stop. After hearing learned counsel for the parties, comma, in the interview, it is directed that the state respondents, particularly respondent number,
Well, it is the government. Lordship may indicate government in the health department.
that the government in the health department
Right.
shall issue the NOC to the
Then they'll consider, madam.
shall
Election to
consider issuing of NOC
in
to the
parity.
petitioners college. However, subject to the condition that the petitioners college cooperates.
If required, my lord, if any information is required.
Cooperates with the requirements
Hmm.
made by the government in the health department.
And they'll maintain parity.
By maintaining parity with the other institutions that have been granted
NOC, my lord, with effect from 2023, 22-23 onwards.
2023-2023 onwards.
My lord, they'll take a decision so that we can within this
Let
year,
such,
month, my lord.
decision be made within a period of 1 week.
Because this month, if it goes, my lord, I'll be finished.
Not that, madam. Let it be 2 weeks, madam, minimum.
Because by the time it comes next week, my lord, the whole purpose will be lost, my lord. Let it be 1 week, my lord, whatever.
There-
Tomorrow, you know, my friend will communicate today.
No, let it be after the vacations, my lord. Cannot be, my lord, within 1 week, madam.
No, you take a decision within 1 week.
That's what-
I'll list it after the vacation.
Either way, my lord, then 2 weeks, my lord. It will be after vacation, it will be 3 weeks.
No, your decision
No,
for
you will
granting
take
the
the
NOC.
decision within 2 weeks, my lord. It will be within the vacation. And on 18, my lord, I will place the decision, my lord.
No.
No, you have to take a decision, grant the NOC.
Lordship will give the outer limit of 2 weeks, my lord. If it is taken within a week, it will be
Let the
communicated.
decisions.
Within 2 weeks,
let the
it will be
decision of
communicated.
the
to the
respondent be taken within a period of
Can we
2
take a note?
weeks.
Yes.
With effect
Within
from
the outer
today.
limit of 2
With
weeks.
effect from today.
With effect from today.
Lordship.
List the matter again after the summer vacation.
My lord will only clarify, my lord, that in the event they require any information, that we will produce, my lord. That much, my lord,
Oh, my
clarification.
lordship has already.
It is right here that in the event the state respondents
They'll communicate to
require
us.
any permission from the petitioner.
We will provide.
the
Like,
petitioner's
can I have a
shall
copy of the
provide.
order today itself? At least I can
Yes.
communicate.
Much obliged, your lordship.
Obliged.
Twenty-four of Delhi.
Please, your lordship. So in this, I am challenging the selection of the private respondent to that of a grade 4 post, my lord. Here, my lord, the private respondent has filed his affidavit saying that he was selected pursuant to advertisement, selection process initiated by an advertisement. But if my lord may come to the RTI reply, my lord, at page 8, the RTI application is at page 7, no? Annexure 7, my lord, page 38. Page 38 is the my lord, RTI application. Lordship may come to the query number 2. Selection process of the above mentioned post and selection and detailed marks in interview, if any, of Mr. Sanjeev Bordle, the private respondent, along with the same obtained by all other candidates applied for and appeared. Now, my lord may come to the next page, is the RTI reply. Number 2, my lord. The matter is related to compassionate ground appointment only.
Yes.
But the private respondent says that he was selected pursuant to a recruitment process, my lord. But, my lord, the affidavit has not been filed either by the school or by the department, my lord. The affidavit will be required, my lord.
My lord, whatever may be the case, my lord, the case is that in a provincialized school, managing committee cannot appoint any employee, my lord. This is the main crack of it.
Yeah, who appears for the government?
Elementary education department.
Elementary.
Similar case was dismissed, my lord, on 12/6/2023 by the court number 10, my lord, in WBC number 6980/2021.
Who is the judgment?
WBC number 6980/2021, order dated 12/6/2023.
Who is the order?
Order, my lord, I have got the soft copy, which says that in a provincialized school, my lord, the managing of the committee has no power to appoint any employee, my lord, or engage any employee on.
My lord, the challenge here is to the appointment of the private respondent.
And I was
So-
appointed pursuant to selection initiated in the year 2005, my lord. I've given the affidavit in opposition stating everything.
That is why, that is exactly the
Then what
issue
does
for.
the RTI say?
RTI, my
says
lord,
you are
RTI,
appointed on
that
compassionate
is,
grounds.
no. I was not appointed commissioner. I was related to regular selection process throughout the Assam, more than 350
Let us have
candidates have been
a
appointed.
affidavit from the state respondent.
Let them file it. She will file it. Verifying this thing.
Heard Mr. P.T. Nair and the constable. petitioner. The respondent number, private respondent number,
I'm for 9.
9.
Yeah.
As file counter affidavit, stop. Mr. N. Fukan.
A. Fukan.
A. Fukan, is understanding council. Elementary education is allowed how much time?
2 weeks.
It's allowed 2 weeks time to file counter. List the matter after 2 weeks.
My lord, the school has not appeared.
School notice has not gone.
Notice has gone.
I mean, dusty service.
We have taken dusty service as well, my lord. The records from the school will also be necessary, I guess, my lord. We have filed an affidavit after the dusty service, my lord.
They file affidavits.
Affidavit filed on, my lord, 1/10/2021.
Records must be with the director of his matter. The appointment record has come to director.
Let us see. Fukan, you file.
Lordship will have it after vacation. Lordship, I will have it after the vacation.
Yes,
A date may be
25.
given, my,
after vacation difficult.
deeply obliged.
25. 25, Lordship, I have received the affidavit after vetting that now, Lordship. I am filing it back more, Lordship.
My lord,
Yeah.
the gentleman is my lord 55 years old. Now, my lord.
Maybe, but I have
this
received,
stress,
I
my
have
lord.
got it tomorrow.
Yes,
In
it is
years,
filing his affidavit by
25,
tomorrow.
55 years or 56 years.
Then
so that doesn't matter.
can it be posted on Monday, my lord?
That will be difficult. Affidavit will not come on record. If he's filing tomorrow,
Yes.
it
I have
will not
received just
come on
now.
record.
I'll file it by tomorrow.
We'll have it after the vacation.
My lord,
It
before
will-
vacation, my lord, any
it
date. my
will
lord.
be
2 weeks,
difficult.
nothing will happen. Lord.
It will be difficult.
Now, this man, my lord, 55 years have already, my lord, closed, my lord.
So let it come after the vacation. We'll see.
Then date may be fixed, my lord.
Third, M.U. Mandal, learning counsel for the petitioner. Mr. S.M.D. Chisti, learning standing counsel.
Secondary education, Lord.
Secondary Education submits that he is filing his affidavit by tomorrow. I.e. tomorrow is what date? 23rd. Stop. Accordingly, list this matter after the summer vacation. You can make a mention.
Oblige you.
Oblige. My lord, second is my lord, identical issue, my lord. Let it be posted.
Chisti here also same, you are filing a counter,
Yeah, here we have filed our affidavit.
you have filed.
Yes, yes, yes.
So let it be posted, my lord, along with the, my lord, since identical, my lord, issue, my lord.
Okay, third, Mr. M.U. Mohammed, counsel for the petitioner. So list the matter after the summer vacation.
Chalo. Allah.
27.
27.
May I please, your lordship. Also, we have received the affidavit today
Here
itself.
we have
your
filed
lordship.
our
So,
affidavit today.
matter
You
may
have to
be,
file a reply.
yes, your lordship.
Mr.
I.H. Laskar.
I.S. Laskar and the counsel for petitioner submits that he has received a copy of the counter affidavit filed by respond number
Respondent number, my lord. I'm the respondent number 1 secretary, man.
by the respond number 1 this morning and press for some time to
Your lordship, a date may be fixed, your lordship.
file, press for some time to file affidavit. And stop, if so advice, stop. List the matter after the summer vacation.
Your lordship, a date may
I
be fixed.
cannot fix after summer.
After vacation.
After vacation.
Oblige.
Oblige.
28. Lordship, in this case, my lord, the petitioner has challenges the provincialization order of respondent number 7 and 8. My lord, the petitioner is the social science
This
teacher,
is the provincialization matter,
my lord.
then you will list it
Section
up.
14.
No, not section 14. That special bench. We'll wait,
Excellent.
we'll wait for the special bench. Okay, on request made by parties, list the matter of the summer.
Oblige. 29.
Second.
My lord, this is a matter wherein, my lord, the challenge is to the constitution of a managing committee of a school called F.A. Memorial High School, Alamganj, Dhubri. My lord, the requirement is that the school, my lord, there will be a meeting. From that meeting, there will be a nomination of people. The inspector will forward, the headmaster will forward it to the inspector with the recommendation. This is important, my lord. With the recommendation of the deputy commissioner, it will be sent to the government. Accordingly, the petitioner's name along with other was sent. Subsequently, there was some, my lord, modification in the partial modification of that notification, laying down the procedure. And the government, my lord, invited further names. This was done, I did not know. My lord. Further 2 names were sent, which included the name of the respondent number 6. Accordingly, my lord, the respondent number 6 was appointed by the, was nominated by the deputy commissioner. Appointed, because it was approved and he was appointed. I made a challenge to that. My challenge is, my lord, on the ground that the person concerned, he is not within the resident of the local jurisdiction of that area. Now, my lord, that term is a very vague term, my lord. It can expand to a very great extent. What would be a local jurisdiction, my lord, of a person to get this? But the important factor here is, my lord, everything requires the approval and the involvement of the deputy commissioner. A deputy commissioner has a defined jurisdiction. He can't recommend anybody beyond that. So here, the person belongs, my lord, although they say that they are around 800 meters or 700 meters from the school, but the place where the respondent number 6 resides is in a different district. And the school is in a different district. There is already a notification, my lord, there is an RTI reply by, my lord, the inspector of schools, wherein he says, page 95, my lord.
Page 95.
95, my lord. With reference to the subject cited above, I have the honor to inform you that as per government guideline of high school, principal of HS school, inspector of schools, DEO, and additional deputy commissioner have no power to recommend or select any person as a president of SMDC of high school, HS school of other district. 95. With reference, my lord has got it.
Running page 95.
Running page 95.
Here it's an affidavit in reply.
It's an affidavit in reply, my lord. 91 it starts. The last is 95, my lord. With reference to the subject cited above, I have the honor to inform you that as per government guideline of high school, principal of high school, HS school, inspector of schools, DEO, and additional deputy commissioner have no any power to recommend or select any person as president of SMDC of high school, HS school of other district. Now, why this is happening, my lord? If my lord can come back to, I'm sorry, my lord, page 27. That's the norm.
There's
This
a
is-
partial modification to this notification.
There is a partial modification, but my lord, what is not being changed is, my lord, page 28, my lord will have the president, one local educated reputed citizen having no political career. After this, my lord would come to page 30, my lord. Just to understand that word local. Selection process of president and vice president of SMDC. The inspector of schools, after consultation with the principal, headmaster, and local people, will forward 2 names to the director secondary education for each president and vice president with the recommendation of the deputy commission within a period of 30 days. After considering the names, the director will provide file list to the government with his comment for selecting single name. After comparing data of both candidates, then the government will approve the committee. Now, my lord, what has been modified is this last line. Now it is the deputy commissioner and the guardian minister who will, my lord, discuss, approve, and then the appointment would be made. Now my appointment, my lord, would see my nomination was made in pursuance to a meeting. I'll place, my lord, the affidavit of my friend, my lord, respondent number 6, which starts at page 57. This school is in Dhubri district, border. My lord would see page 57, his details, my lord. I, Riazul Rahman, aged about 38 years, son of late so-and-so, in the district of Kokrajhar, Assam. Do hereby solemnly affirm and state. Then his justification, page 59, para 4. That the deponent begs to state that the said school is situated in village of Alamganj, part 2 of Dhubri district, at the western side of NH 31. The deponent is although a resident of village Dampur 2, but it is adjacent to village in which the school is situated. As the village Dampur 2 is also falls in the western side of so-and-so, erstwhile village Alamganj part 2, Dampur part 1, Dampur part 2, Geramari part 1 was under the district of Dhubri. But after formation of Kokrajhar district, the village Dampur 2 falls under the district of Kokrajhar. The whole area on the western side of NH 31 falls under Kokrajhar district, except the concerned school, which might have been done on the demand of the district administration. So the school is in Dhubri district, my lord. Then my lord would find page 61. line 5 from bottom, my lord. Right hand side. Thereafter, the respondent number 8 prepared the second panel list of 2 persons having the name of the deponent and another and forwarded the same to the concerned authority for further steps as per norms. And my lord, page 62, the last paragraph. Further, in the said notification number so and so issued by the respondent number 1, there is no condition stating that the candidate of West president, vice president should be from the same village where the school is situated, but it is stated that the aspirant so and so should be a local resident. In both the cases, both the writ petitioner and dependent are local residents of this area where the school is situated. Now, my lord, the partial modification my lord would have page 69, wherein, my lord, they say that the panel should be second paragraph, my lord, or first paragraph. In continuation of this office letter that I mentioned, I am to inform you that it is resolved to obtain the name of 4 persons instead of 2 persons for selection of president and vice president, which is to be constituted soon. Now, my lord would have the affidavit by the inspector of schools, my lord. It starts at page 77. Relevant, my lord, 80. I'm just saying, my lord, that my lord had raised a query. There was a partial modification, but the selection was made in terms of 24/6/2016, that page 27. That will be clear from this one. Your deponent further states that the respondent number 6 is a resident of so-and-so, Alamganj district, Kokrajhar, Assam. The distance of FA Memorial High School, Alamganj, and the residence of the respondent. My lord, page 80, top portion, my lord. My lord has got it. Your deponents further. Page 80, my lord, 80.
Is it internal page 4?
Internal page 4, man. Sorry. Your deponent further states that the respondent number 6, Malay, am I right? Malay, it's an affidavit which starts at page 77. There might be some mistake, my lord. It's an affidavit in opposition by respondent number 4, my lord.
Is it continuation of para 4?
It's continuation of para 4, my lord.
What is it?
Para 4, my lord, it continues from page 2 to 3 and, my lord, 4. Well, my friend will give a copy.
Oh, this page 77 is affidavit in reply.
I'm sorry, my lord, there might be some mistake in my marking, my lord. It's an affidavit in opposition by respondent number 4, my lord.
Yeah.
80, 77 to 90. My lord, it starts at my page 77, but my lord will have that copy which my friend has.
No, I have it here.
Lordship. It's just above paragraph 5, my lord.
Yes.
Your deponent further states that the respondent number 5/6 is a resident of village Dampur. The distance of FA Memorial High School, Alamganj, and the residence of the respondent number 6 is 800 meters. Moreover, it is also pertinent to mention here that the selection of the president of so-and-so of the said school was made as per criteria laid down in the government notification dated 24/6/2016. So allegation regarding so-and-so. So, my lord, there has to be a public meeting in terms of that. The deputy commissioner will then, and if the deputy commissioner is nominating, my lord, then there has to be, deputy commissioner cannot nominate in terms of page 95, somebody who is outside his jurisdiction, my lord. Then, my lord, we'll have page 82. Same thing, my lord. That everything was done as per 24/6 pay para 12, my lord. I'm not detaining your lordship there. Para 12.
Something is wrong, the paging.
My lord, that internal page 6 of that affidavit.
I am sorry.
Yes.
Here also, my lord, it says that this school-based selection was done in terms of the government notification dated 24/6/2016. And now, my lord, the partial notification, which my lord would find at that same affidavit, Annex 1. It's page 10 of, internal page 10 of that
Yes,
affidavit.
yes.
It's 27/10/2021 in partial modification of the guidelines for constitution of so and so issued by the government dated 24/6/2016 and the letter dated 5/4/2017. The deputy commissioner is hereby empowered to select the president and vice president of the school selection, school management and development committee of an educational institution of the concerned district with the approval of the guardian minister. So, my lord, when a deputy commissioner is selecting, he cannot certify somebody beyond his jurisdiction. It will have to be within the jurisdiction. And that read with, my lord, page 95, the notification, my lord, notifying the respondent number 6 as the president, my lord, cannot sustain. This is my observation. Notification.
Was that impute order?
My lord, I'm placing that. The impugn order, my lord, would find it's in the additional affidavit.
Not in the main writ petition.
No, my lord, we got it subsequently. Page 44, notification is at page 48. It starts at 48. Down. Malad has got that notification 48
Yes.
issued by the deputy commissioner for Dhubri district. The relevant is, my lord, page 51, my lord. Serial number 46. Respondent number 6, my lord, Riazul Rahman. And there is an interim order, my lord, operating, for which, my lord, the respondent number 6 could not get it.
Yeah, response 6.
Respondent number 6, my lord, serial number 46 there.
You have nothing against the vice president?
No, I have nothing against the vice president.
Yes, Sharma?
Madam, here one is partial notification in continuance to the notification dated 24/6/2016. And as per that notification and 24/6/2016, the panel list of panel has been sent to the authority, and thereafter, my lord, with the approval of the guardian minister and more.
Qualification could be as with the
approval of the guardian minister. So, my lord, the panel has been made with the approval of the guardian minister, my lord. And the deputy commissioner also is a very important role to do, my lord. So, here deputy commissioner is mainly responsible or answerable to it, my lord.
Who's the deputy commissioner?
Yes, deputy commissioner is.
Where's your affidavit?
No affidavit.
Are you not supposed to file your affidavit?
My lord, I have received the instruction from the inspector of schools, Dhubri, my lord.
No. You are the deputy commissioner. You have to get instructions from the deputy commissioner Dhubri. Issue is this. The respondent number 6 belongs to Kokrajhar district. Deputy commissioner belongs to
Dhubri
district. Now, I'm sure there will be a deputy commissioner of Kokrajhar.
Yes.
Can he encroach into the jurisdiction of deputy commissioner of Kokrajhar? That is the only
Ultimately,
issue
my-
involved in this petition.
That's the only issue.
Ultimately, my lord, deputy commissioner is empowered to select the president and vice president. of
That's
the-
fine, that's fine. But from amongst whom?
From other district.
From amongst whom? Local residents, it says, correct?
My lord.
Now, where to respond 6 is a local resident of Dhupri. Now, where the school is situated.
My lord. So, my lord, to that effect, let me get the instruction, my lord. I think you want. Can you do it on Monday, my lord? I'll get that.
No point in listing, you better file your
Affidavit.
affidavit and then come.
My lord.
It's a simple issue. Just have to say that what you have done.
That's it.
Whether you selected that person from Kokrajhar or from Dhupri. That's all.
My lord, otherwise, this is empowered to appoint, my lord. Well,
That we are not questioning the.
My lord,
Deputy
Empower.
Commissioner
My lord.
authority. All that we are questioning is how he has done the selection.
My lord.
And
Oh,
let-
how
Whether that respondent number 6 belongs to
Okay.
Kolkata district or not.
Not selection as per your affidavit, as per the affidavit of inspector.
My lord.
It's as per the notification dated 2016.
16.
So whether the deputy commissioner, how he has done his, met his recommendation. Not selection.
And my friend will also keep in view, my lord, that page 95, RTI reply by the inspector, my lord, wherein says you cannot select somebody beyond the district.
Yes,
So, I have seen, my lord. My lord, I'll file a response for now within a
but
very
you
short
can
time.
iron the senior counsel, assisted by Mr.
Islam.
M. Islam.
M. Islam, learned counsel for the petitioner. Also heard Mr. U. Sharma, learned standing counsel,
For secondary education.
secondary education, and Mr.
Yes, Alam.
S. Alam.
Yes.
Learned counsel for respond number 6.
Yes, sir. I have a additional commission, Lordship.
On request made by G. Beku, learning government advocate,
Argument again.
2 weeks,
My lord.
Lordship, after vacation.
2 weeks time is allowed to file counter affidavit
The interim order, my lord, will continue.
after the
Lordship, kindly,
summer vacation. Interim order passed earlier to continue till the next returnable date.
Lordship, kindly turn to the order dated 3/6/2020, Lordship.
3/6,
2022, Lordship.
what is that?
By that order, Lordship, this honorable court directed to clarify the meaning of local person. Lordship. But to that effect, no affidavit has been filed. Lordship.
That the deputy
And
commissioner.
in this regard, Lordship, in this regard, I have filed an ITA application, Lordship. And in that reply, the ISS clarified that there is no one to appoint another person from another district. I have started.
My lord will not go by the RTS because I have one RTA annex wherein he says he cannot.
Subsequently, Lordship, same authority, Lordship.
Local area has no boundary.
Yes.
Doesn't matter.
It's a deputy commissioner. My lord has rightly said, let him disclose his mind, my lord.
I think we'll call him in person.
My lord, he should be giving
Same
two
authority,
different.
Lordship. Earlier,
That we will see.
My lord, the interim order will continue.
Order passed.
Much obliged.
30.
The local person.
Made with the Lordship.
What
As
is this report?
directed by your lordship, my lord. I have come back with instruction, my lord. Having regard to the marks in the SCR, my lord.
What matter was this about?
This is, my lord, that regarding appointment of principal, my lord, regular principal. Advertisement is at page 32, my lord.
Yes.
Here, my lord, advertisement is okay, fine, my lord. We have not challenged the advertisement. Page 32 and 33, my school is, my lord, last serial number 14. But already Kolangau Senior Secondary School, Kolaigaon. We have challenged the, my lord, here, that violation of guideline by the selection committee. Guideline is at page 45, Annex 3. Page 45. Revised guidelines for selection of principal of provincialized higher secondary school relating to award of marks as per new service rule 2018. Then your lordship may come to my lord, page 46. Page 46. No, my lord, here itself, page 45, here, my lord, 3, serial number 3, integrity and personality 3, my lord, ACR for last 2 years, proceeding the year of selection. Violation of particular disclose, my lord, serial number 3, that ACR for 2 years, proceeding the year of selection.
1 minute, 1 minute.
Yes. Academically, he's much poor man than me, man. And there are other grounds also, but more particularly violation of this clause, my lord.
Which clause? 3.
Clause 3, my lord. Here, my lord, it is marked as, my lord, good, number 1, my lord. 1 marks will be awarded. Very good, 2 marks will be awarded. And outstanding will be awarded as 3 marks, my lord. But in the present case, my lord, record is your lordship, my condition. He has been, my lord, given a note of, my lord, that he can be considered for next promotion. Instead of giving marks, my lord, comments, my lord, good, very good, or outstanding. That has not been given by his superiors. He has been given, my lord, he should be considered for next promotion.
1 minute.
Then, my lord, I filed an affidavit. After going through the record, I filed an affidavit, my lord.
1 minute.
SP
1
57.
minute.
Yes, sir. He decided.
The private respondent is?
Respond number 6.
Number 5. Bokanta Saike.
So he was awarded two marks.
3 marks, man.
No, 2.
Man, 3 marks for ACR against Bokonto Hoike and 2 marks to the petitioner, Robindra Sauriya.
Yes, yes. 3, 2.
Yeah. Now, the director is saying that the comment in the ACR is equal to 3 marks as decided by the selection committee, my lord. That is
No,
what the
1 minute.
instruction of
1
the
minute.
bill.
Let us hear. Yes, first.
Yes, after going through the records, my lord, hearing was also completed. I was directed to file an affidavit, additional affidavit, that is at page 57, my lord. If your lordship come to page 58, my lord, paragraph 4. The petitioner further states that the honorable court, after going through the records, referred the relevant records to the counsel for BTC and the counsel for the petitioner. After going through the records, both the counsel found that the respondent 6, my lord, means Sri Basanta Sakia have been illegally allotted marks by the selection committee in violation of guideline dated 22nd June 2021. He has been allotted marks 3 against ACR, although the marks given in the ACR is not as per norms laid down in the guidelines. He has been given remarks. He can be considered for next promotion. As per guidelines, remarks should have been given as below: good 1, very good 2, outstanding 3. In case of the petitioner, in his ACS, remarks has been given as very good and he has obtained 2 marks in that category. The petitioner states that category of administrative ability, the respondent has been given 1 mark and the petitioner has been given 0 marks. As per guideline to measure administrative ability, award 3 marks, national award 1 mark, state award 1 mark, district award 1 mark. So he has been given, but that category also, my lord, he is not entitled to. In respect of national award, award should be given by Government of India. In respect of state award and award should be given by the government of Assam, and in respect of district award, award should be given by the district administration. In case of respondent number 6, my lord, he has not been given any award by the above mentioned authority. As such, he does not deserve any mark in that category. Hence, the respondent number so-and-so has been given 4 marks illegally and in violation of the revised guidelines dated so-and-so. The petitioner respectfully submits that the petitioner has been allotted 16 marks and the respondent number so-and-so has been given 18 marks by the selection committee. Out of 18 marks, the respondent number so-and-so given 4 marks illegally in violation of the revised guidelines. In that case, the respondent number so-and-so would be 14 only and the petitioner marks should be 16 only. On the other hand, the academic career of the so-and-so in marks inferior to the petitioner, and he has passed the graduation on grace, 10 grace marks. Graduation also. Petitioner school is having about 1100 students, whereas the respondent so-and-so school was having only 50 students, where he was earlier working, my lord. As such, the Honorable Court may kindly pass order directing respondent to appoint the petitioner as principal officer of Kolagaon immediately in place of so-and-so.
Your case is that the selection process is vitiated.
Yes,
isn't it?
my lord, because
On
of
the
the
ground that-
violation of the
So
guidelines,
far, number 1, Asia marks.
ACM marks, and my lord,
Number
another
2,
mark-
awards.
yeah, award.
And number 3,
Number 3, my lord, his B.Ed degree is also, my lord, and a challenge, he has not taken on leave, my lord, while going to a B.Ed degree, and my lord, he
is
has
that the
his
fresh,
grace marks.
is that the fresh ground you are taking
Grace marks.
today or?
Which
you have
one?
met in your
No,
affidavit?
my lord, it is there. Earlier, my lord, that case, my lord, I have not challenged the advertisement because I also goes out there, my lord. That's why last occasion, my lord. You're not
Why are you challenging the advertisement?
Well,
Here.
this one I am not challenging the advertisement because it is not as per my lord rule. I am
You're
not challenging the
challenging the
advertisement.
selection process.
I am challenging the selection process because of violation of the guideline.
Appointment has been made.
Yes, my lord, it is in my lord.
My lord, I have joined. I have joined.
Yes.
After a couple of months, she has before this. After
Impugn
my-
order is that my lord. Impugn order is that my lord. Page 41, my lord. Page 41. So on recommendation of the council level, selection board and in pursuance of BTC approval accorded and subject to revision without notice and without assigning any reason thereof, Basanta Sarkar,
Just open.
MAB at and appointed to the post of principal on regular basis in the scale of so per month and present. In charge of principal month. Your lordship, my lord, can we see the comparative statement, my lord? From the record, your lordship, my lord, may kindly see the comparative statement. Here the marks is, my lord, much lesser than me, my lord.
Where? Page.
HSLC, I got 47.40%. He got, my lord, 41%. Higher secondary, my lord, I got 46.30.
You're
He
reading
got
from
40.
which page?
Yes,
Which page?
this page has not been, my lord, annexed there, my lord. Your lordship can, my list. If
Will you furnish copy to the architect?
My lord, before taking this matter for final disposal, my lord has seen the instruction produced by the director of BTC, my lord. Here it is stated that the decided and allotted by the members of the committee. Now, my lord, she is the only ground, my lord, principal ground is regarding the ACR marks. Now let the committee come up with a reply. That is all, my lord.
But the committee is a
But the
party.
committee has not been added as a party. That is why I have raised the ground of maintainability in my affidavit.
Today, my lord, that is in so many cases where you are not, sir, not making party. The committee is not a party.
Regarding the marks,
Is there,
allotted,
my
it is the
lord?
committee
Court
who is
will-
going to
no, my
clarify,
lord.
my lord.
State is there,
The
it
writ
is
court
under
is not
them,
the expert body.
and yes, my lord, government is there, government will reply for their action. And it is not necessary, my lord, so many cases are going on where, my lord, committee is, my lord.
Committee reports are
making
here,
party.
isn't it?
Committee is not required, my lord. Your lordship will see the
Oh,
merit, their action
lord.
only. Scrutiny, their action only.
Everything is on the
Which member, I don't know.
Selection committee records?
Yes, my lord.
Yes, that is there. The record is there. Only to delay the matter, they want that committee should be at, my lord. In so many
But I have
repetitions where-
already joined, my lord. There is no point of delay.
That's okay. Baba, you'll have to fleck it properly.
they have violated the,
You fleck it properly and submit it.
Right now, my lord.
Now it will not be possible.
Let it be taken up, my lord, after vacation.
Okay.
yeah, my lord.
Short terms and cycle when you come.
Committee is not necessary party, my lord.
Okay.
Committee is not
Request-
necessary party because we don't know, my lord,
request,
who are the
uh,
members.
by the Standing council.
Why they should be burdened, my lord, unnecessary.
It's the matter of the summer week. You take it back. You fleck it properly
Like-
and.
Yes, my lord.
with-
Record should
with
be in the
with
court only, my lord.
Records.
I think, my lord, record should be in the court, my lord. Earlier hearing also, my lord,
He has to. fleck-
honorable judge
he has
kept
to
the,
fleck it. He has to fleck it.
arrange it. After vacation, my lord.
Yes.
31 to 36.
Yeah, it's going right.
Yeah.
My lord, these matters can be disposed of subject to my lord's convenience. Only thing here is, my lord, we were provincialized. There is an order of provincialization. Now, the Provincialization Act requires that the preceding 3 years, we must appear in the HSLC, students appearing in the HSLC, 30% pass should be there. We have that. We were provincialized. My lord can have the first case, my lord. My lord comes to page 22, my lord.
Yes.
My lord, it is a notification of 4 January 2021. My lord has got it.
Hmm.
Top, my lord. Now, the act says that the date of provincialization would be the date of notification. Now, my lord, permit me to read. In pursuance of letter dated so and so, the government of Assam, in accordance with the provisions contained in the so amended in and the so amended Act 2018, Governor of Assam is pleased to provincialize the services of teachers, tutors, and non-teaching staff of Diglatari, High Madrasa District, Dhubri, with effect from 1/8/21. This is the first, my lord, mistake made in my case. It should be, my lord, 4/1/21 or 1/1/2021. Subject to the condition that their performance and number of students in HSLC examination 2021 conform to the eligible standards and with the following terms and conditions. Now, my lord, this last line is without any basis. That is not the requirement under the Act. This was done by the authorities in their executive capacity. The Act does not provide for that. In spite of that, my lord, 2021, all the schools involved therein
Are you putting this under challenge?
Yes, my lord, that date I have put to under, the condition I have put under challenge, my lord. My lord would come to the prayer at page 17, my lord. Page 17, to issue a writ in the nature of certiorari so and so, setting aside the order dated so and so to the extent of imposition of arbitrary condition pertaining to subjecting the provincialization of the petitioner to the performance of the education institution and number of students in my lord HSLC examination 2021.
Where is that?
Page 17, my lord.
No, no.
First one, first prayer, my lord.
Where is that in the notification order?
Order, my lord, in the last 3 lines, my lord. Right hand side, 3rd line from bottom, my lord, first paragraph. Subject to the condition, right hand side, my lord. My lord has got it. Just after the bold with effect from 1/8/2021, my lord. Subject to the condition that their performance and number of students in the HSLC examination 2021 conform to the eligible standards and with the following terms and conditions. So that's not maintainable, my lord. Then the second prayer is, my lord, page 17 back again, to issue a writ in the nature of so and so, setting aside the order dated so and so to the extent of the saying being made effective with effect from 1/8/2021. It should be with effect from 1/1/2021 to all the colleges and schools it was made, and the act also says that. So if these 2 conditions are clarified, my lord, I get my salary start. And my friend will give in the other cases, my lord, the date of the page and the, my lord, the salary if received, the months, my lord, he'll give it, my lord, to, if subject to, my lord, my friend's version.
Look, basically, this decision was taken pursuant to a meeting held at page 32, my lord, the minutes. The relevant portion, my lord, page 33, serial number 2.
Page 30.
Page 33.
It is Pishoro, subsequently.
Otherwise, my lord, if I go by section 4 of the act, my lord.
19 February.
It is, my lord.
This later on, after the order.
After the orders, 1 year afterwards, 28/1/22.
The prime challenge, my lord, to regard to the date of effect at the condition which has been imposed. My lord, to be fair, my lord, the act does not permit. So. Section 4, my lord, it says, my lord, the provincialization will be from the date of
Notification.
Which act?
my lord, 114, my lord.
Page 114, section.
This provincialization were done under section 4 of the act. 114. Section 4, my lord, may I read it? Subject to fulfillment of other provisions of this act, the services of teachers and tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become the employees of the state government with effect from such date.
So when is
So,
it, when
So
was it
that
published?
notification, my lord, apparently page 22. So, my lord, it is on 4th of January 2020.
No, no, when was it published in the Gazette?
It's
No.
4th of January 2020.
4th of January.
2021.
2021.
Yes. So apparently 1 August 2021 is wrong,
Wrong.
correct?
Yeah.
And the other conditions?
The other condition, my lord, Roman 3.7, my lord. 3.7 says, my lord, what would be the eligible, section 3 deals with the eligibility criteria. So prior provincialization, my lord,
Section 3,
Roman 7, my lord.
No, 6. Roman 6. In case of venture high school or venture high
My
school.
lord, the section
6,
3,
man.
Roman 6. Sorry.
It's in page 109. man.
109.
Down below.
My lord, finds 109.
yes.
Down
Maybe.
below Roman 6. my lord. In case of a venture high school or venture higher secondary school or venture junior college or a venture degree college, the venture educational institute must have a consistent good academic performance, which would mean at least 30% of the candidate appearing for the final examination as a whole must have passed in the last 3 consecutive examination held during previous 3 consecutive years prior to the date of coming into force of this act. So, my friend appearing for the SEBA has produced before this honorable court, submitted the
It's there.
the 3 years past consecutive record, my lord.
Of the
All the colleges,
Of the- all-
schools involved.
All the schools.
including the
it shows-
petitioner school?
Yes.
Yes. One school, my lord, Mohesh Boisho Girls High School.
1960.
They had 29% in the year 60, and rest, my lord, the other school they had more than.
T-shirt here boy लेने की इधर modify कर लो महेश बशु
You are aggrieved by this HSLC examination 2021.
2021 because
It should be prior to
3 years and that they have satisfied and they provincialize us.
prior to the provincialization of your school.
Lordship, that's the requirement.
3 years back.
3 years back, which we have, they are satisfied with that, they provincialized us. Now they put an additional condition, go and clear up 21 also. We cleared up 21, even if my lord says that condition, we have cleared up 21 also. More than 30%, 70, 80, 90%, madam. Some even 100%. But still, the salary still date has not been filled. That's my limited point.
Why are the salaries not released?
Well, this because of
Supposing if this 2021 is also not interfered with.
Mal.
Then the council is saying that they are satisfied.
yes
2021.
then the 20% to 2021, my lord, they are entitled.
Now, why are they not their salary?
So that's the question I don't have that whether they have been paid or not. My senior says, well, some of the schools they have been receiving salary for 2 months.
One before, my lord, 1 month, 2 months we have received. After that, it was stopped. And this is all thing is being done by some my lord committee is there. That committee is acting as an extra my lord judicial body.
What?
It's a my lord meeting of the screening committee purportedly.
Under which provision of the act?
Nothing, my lord. There is no, the provision of the act, that screening committee finishes moment the school is provincialized. My lord will find at page 32, even after my lord 1 year, they are going behind the schools, my lord, for reasons unknown.
This screening committee, my lord, was constituted, my lord, including the personals from SEBA finance department, so as to verify, my lord, after the provincialization also, if whether the conditions that has been laid down in the act has been fulfilled or not.
What conditions?
My lord, the section 3 are the only condition, my lord, which has to be fulfilled. If section 3, the conditions laid down in section 3 from Roman 1 to Roman Roman 12 If that is fulfilled, then their provincialization is done under section 4. To that extent, matlab, the coming into force, matlab, I leave it to you, because otherwise section 4, matlab, I cannot go beyond that. Section 4 clearly
Section
indicates-
4 that I'm clear on
yeah,
that.
clearly indicates.
Only
matlab,
the issue is why the salaries are this.
So that basically matlab, from the page 32 minus matlab, it indicates page 33 the Roman 2 matlab.
Page 32, what minus? This is a
That's-
minute of after the.
Afterwards,
poll
matlab,
was
you
That's it.
applied.
find page 33 Roman 2 matlab. The intent of putting this condition, Roman 2 matlab, the committee decided that the proposal relating provincialization of 13 schools, high madrasas showing good poor results in the last HSC received from director secondary shall be referred to
SEBA,
verification.
SEBA for verification.
SEBA for verification.
Whereas the SEBA
Matlab, the-
verification report was already there.
Because there were some certain schools which had a very poor results from it, and therefore the condition was imposed.
So it was a blanket order saying that no salaries will pay to all the schools.
There is
Or
a
have you considered all the particular schools
No,
the school,
separately?
yes,
13
it's
schools.
page 25 matlab.
13 schools you have mentioned.
Yes.
Does the petitioner school come under these 13?
Yeah,
My lord, that page 25 is the
25
order.
is the communication matlab. It was a general communication to all the inspector of schools of
For
13
these
districts,
13 schools, my lord.
all 13 districts matlab.
13 district, no. 13 schools. No, 13 district. no.
13 schools of various districts.
And this is illegal. With reference, I have the honor to inform you the government has accorded creation of so and so with effect from 1/8, subject to the condition that their performance is conform to eligible standard. In this connection, stated that office has lettered to SEBA for verification of these 13 schools where this office may be under reference. The schools are there. My lord, the present school is at serial number 5. You are therefore requested not to release the salary of teaching and non-teaching staff of the above mentioned schools until further instruction from this end. Now, my lord would come to
This, Kaushik, I think you have to file an affidavit
Well-
making a position clear.
Well,
So
My
far,
lord-
the date of provincialization is concerned, there's no need to file an affidavit.
yes, with regard
Because
to
this, the act is very clear.
Yes.
There's no issue on that. That can be interfered with at any point. But what is the problem with the schools?
my lord would have one page, my
the
lord.
other conditions.
My lord would have one page. That's a letter from the page 30, my lord.
Yes.
My lord, this is a letter from the director to the principal secretary. The first paragraph, my lord, laid down the conditions. Second, my lord, paragraph says that the report has been received from the SA. I have my lord's attention, third paragraph. As per report of SEBA, 10 numbers of schools have shown better performance in HSLC, HM examination. As such, they have fulfilled the criteria of provincial. It may mention that out of the 13 number schools, 3 numbers of schools, namely Bongaigaon Vidya Mandir, Azara Soneshwar so-and-so, and Motola High School, have failed to fulfill the criteria of provincialization. The remaining 10 schools may be allowed to receive salary. List of 10 schools is enclosed at Annexure B. As such, government is requested to accord necessary approval for release of salary in respect of teachers and tutors of the 10 numbers of schools. That 10 numbers, my lord, would find on page 31. Serial number 4 is the school before my lord is now considering, my lord. And the other schools involved in this series is also there. So my lord may direct them. I have no issue, my lord. My lord will satisfy your lordship that why this is, but the current salaries, my lord, that may be directed to be issued. Clear, my lord. Otherwise, my lord, 2 years without anything, how will the standard of the school be maintained?
Yes.
Well, this lordship will clarify that 3rd January 2022, this communication, madam. Because this is a communication to the government from the director. This otherwise it's clear, madam. This 10 schools, madam. After 2021, the condition which was imposed in the
Where was that
provincial-
other order, but
Page 30, my lord.
no, 30 is okay.
Then, my lord.
That earlier order,
My lord, AD order 22, my lord.
the provincialization order is a specific.
22, my lord.
no, this Page 25.
Page
25.
This
That was, my lord, subject to till the SEBA report is received, my lord. Second paragraph. In this connection, stated that the office has written a letter to Secretary SEBA for verification of academic performance of these 13 schools, while this office letter number mentioned under reference. Serial number 5, Diglatari High School. That letter, my lord, from the SEBA is at page 26, my lord. With reference, I'm subject to survey, I'm submitting here with the records of academic performance of HSLC examination 21 of the schools mentioned, while letter dated so and so. My lord would come to the next page, serial number 5, Diglatari High School, 28 appeared, 28 cleared, 100%. And similarly, all the other schools, my lord, involved have the same results, my lord. More than 30%, my lord. If my lord requires, I can just give the names of the other schools involved in the writ petition. My lord can just have a look. The first school my lord has got. Next is Uttar Novoboisia High School, High Secondary School. That my lord would find at page 28, serial number 13. That is WPC number 7615, my lord. Then the next one is Similitola Girls High Secondary. That my lord would find at serial number 10, page 27, 97.22. Then my lord, Borai Bari HS, my lord would find at serial number 8, 100%, my lord. Then my lord, Kakargaon HS, my lord would find at serial number 4, 73%. And the last one, my lord, Mahesh Boisho Girls High School, High Secondary, that my lord would find at serial number 2, 100%. So my lord will satisfy my lord with that instruction. But in the meantime, my lord, let these people not suffer, my lord. Let them be paid their, well, at least the current salaries, my lord. Current salaries, my lord, from the this financial year. That means, my lord, April, 1st of April, my lord.
But Mr. You can hire Learned Senior Counsel, assisted by Mr.
A. Chakraborty, my lord.
A. Chakraborty, Learned Counsel for the petition. Also hire Mr. V. Kaushik, Learned Standing Counsel,
secondary education.
Secondary Education. For the respondents,
1 and 2.
1 and 2.
My friend appeared for SEPA.
And Mr.
TK Roy.
T.K. Roy, Learned Standing Counsel, SEPA, for respondent.
Number 3, my lord.
Number 3. For the services of the teachers of the tutors and non-teaching staff of the Tikhaltari, High Madrasa district, Dukku, was provincialized with effect from 1st August 2021 by an order dated 4th January 2021 issued by the Director, Secondary Education, with the condition that the performance and number of students in the HSLC examination 2021 conform to the eligible standards and with other terms and conditions stipulated in the said order. Stop. Grievance of the petitioner in this writ petition is that in terms of section 4, isn't it?
Section 4.
Section 4 of the Assam Education within bracket Provincialization Act of 2017, within bracket Act of 2017, the services to petitioners should have been provincialized with effect from the date of notification. And that the conditions with regard to the performance and number of schools in the HSLC examination 2021 is not provided in the rules of 2017. However, at this stage, this code is concerned. No. However, at this stage, without expressing your opinion on the two grounds raised by the petitioners, this court is concerned with the non-release of salary of the petitioners of the present school. The i.e. Dikhal Tari High Madrasa District. Stop. Para. The Director of Secondary Education, by a communication dated 11th November 2021, addressed to the Inspector of Schools of nine districts, correct?
Lordship.
9 districts.
Nine district.
Directed, requested stated that the government has accorded approval for creation of 87 numbers of posts of teachers and tutors for provincialization of services in respect of 13 high schools with effect from 1/8/2021. Subject to the condition that the performance and number of students in HSLC examination 2021 conform to the eligible standards. In the list of 13 schools, the name of the petitioner school appears at serial number
5, my lord.
serial number 5.
Just right.
Stop. The communication further states that the office has written letter to the Secretary Seba for verification of academic performance of 13 schools. Accordingly, the Inspector of Schools was requested not to release the salary of teaching and non-teaching staff of the 13 schools until further instruction. Stop. Thereafter, comma, the Director of Secondary Education Assam, by letter dated 2021, wrote to the Secretary Seba.
No, this is a letter from the Seba, my lord. The letter to the Seba is 8/11/21. Page 26 is from Seba, my lord.
Okay.
29 is, okay.
Thereafter, the Secretary Seba, by a communication dated 2011/2021, addressed to the Director of Secondary Education Assam, wrote on the subject of verification of records of academic performance of high schools. And amongst the list of 13 schools,
Lordship.
the petitioner school appeared as serial number 5
Five.
with 100% pass.
Pass percentage.
With 100 pass
Percentage.
percentage.
100% pass percentage.
100% pass percentage. Stop. Consequent thereto,
On the basis of that, page 30.
comma, Director of Secondary Education Assam, addressed to the principal and secretary to the government of Assam, Education within bracket Secondary Department, by communication dated 3rd January 2022. Stated that the that in terms of the report of the SEBA, 10 numbers of schools out of the, within bracket, out of the 13 schools have shown better performance in the HSLC public AHM examination. And they have fulfilled the criteria of provincialization. And the 10 schools may be allowed to receive salary. Stop. The list of the 10 schools was enclosed as Annexure B to the said communication. In the Annexure B appended to the said communication dated 3rd January 2022, the name of the petitioner school
Serial number 4.
appears at serial number 4. Stop. Considering that the petitioner school has confirmed to the eligible standards laid down by the government, comma. This court, no, it's, cancel it. Learned counsel for the senior counsel for petition submits that despite the communication dated 3rd January 2022, the petitioners are yet to receive their salary till date. Correct?
Lordship. After that, no salary.
According, stop. Considering the considering the communication dated 3rd January 2020, inasmuch as the petitioner school has conformed to the eligibility criteria laid down by of provincialization laid down by the government, comma. This court, by way of interim, directs the which authority?
Director. Director, my lord will direct the
Director of Secondary Education.
and the my lord government. Government approval is required. Say 1 and 2.
3rd January, the letter.
Directs the respondent number 1 and 2 to forthwith pay the current salaries of the petitioner effective from the new financial year.
1/4/2023.
1/4/2023. Stop. In the meantime, Mr. P. Kaushik, London Standing Council Secretary Education, shall file affidavit explaining the stand of the government.
My lord, my challenge to that 2 conditions, that will be still open. my lord.
That is open. I've said I'm not entering into that.
Lordship.
List the matter after the summer vacation.
After-
This is one order in one.
My lord,
case.
my friend will, in the other cases, they require particulars, my friend will give it to him. my lord. He'll write down, note down. The same order will
Please
go. my
give
lord.
the details
He'll
now.
do it. He'll just now he'll do it. my lord.
Don't make a mistake.
No, no.
because Again, you'll have to come.
No, my lord, he'll sit with him and he'll give it to him.
Okay.
Much obliged, your lordship.
Thirty-seven and 38.
These are analogous matters, my lord.
Hmm.
Otherwise, pleadings are complete.
Hmm.
But I don't know whether time would permit today.
I
Possible.
don't know, Bhuyan.
Lordship. My lord, that is attested copy of that day on,
Kayan,
yes, sir.
15 minutes.
Okay.
What do we do now?
Lordship,
Next
interior
order
water
This
is
is
separate.
regarding that school.
Correct.
Signing
Correct.
next week, not
Correct.
Tuesday or anything.
Next week, I don't know what to do.
Yes, all motion days.
Or my lord can have it immediately after the vacation.
Okay. On request made by the parties. List this matter immediately after the summer vacation.
It can, date may be fixed.
List this matter.
18th
Is some urgency involved?
No, I am otherwise protected by your lordship in the interim.
Then let there be no date after the summer vacation.
18th of May, Tuesday.
There'll be some chaos. We have fixed dates because it will be immediately after summer vacation, all because.
That
So
may be
if you have some emergency involved, you can make a mention this.
My lord, interim protection passed earlier.
Interim order passed earlier to continue.
And my lord had directed the Learned Council CGSE to provide a copy of the statements. A copy may be given, my lord.
You retain that copy.
এই কপি স্টেটমেন্ট যে কিবা দিয়া বুলি কৈছিলে তার একটা কপি দিয়া আছে এই যে ৰেকৰ্ডৰ পৰা যে স্টেটমেন্ট খিনি দিয়া কথা আছে
Statement, Milo, that is the
Translation
translated copy, Milo.
Yes, yes.
But I'll provide you to court, Milo, translated copy.
a copy may be given to
No,
me
Milo,
also,
that is the part of the proceeding, Milo.
so as to enable it
That is the part of the proceeding, Milo, that may.
Oh, it's a part of the record.
Yes, yes,
Okay,
Milo.
we'll see.
my lord obliged deeply obliged
55 and 56 are supplementary, please. That makes sense.
may I have the lordship.
In this case, my lord, item number WBC number 666.
Uneasy and left the court. Kindly,
What is it?
my senior Mr. HR Shetty was in the waiting in the court. Now he's feeling uneasy and left the court. Can you adjourn the matter?
My lord, in WBC number 666, 2019, my lord, the order is there already by your lordship dated 9/9/2022. The report has already come, already submitted by the government, my
By the
lord.
way, his senior is not the.
Yes, yes, my lord.
Heard Mr. P. Kurga yesterday and the counsel for the petitioner. In both the writ petitions,
I'm in one, I do not that.
in WBC number 666, 2009. So on request made on behalf of Mr.
J.M. Sulaiman.
A.
J.M. Sulaiman. J.M. Sulaiman.
Learned Council appearing for respondent number. Appearing for
Petitioner.
respondent number.
55 item.
This for the
Petitioner.
petitioner.
Oh, on request made on behalf of J.M. Solomon, Learned Council for the petitioner. In WBC 4492 of 2015. This is the matter after the summer vacation.
Date, may I pray, my lord?
Difficult. You'll have to make your own arrangements.
57.
Let it come, Manoj, it'll take some hearing, Manoj. Let it come after vacation.
On request made by.
तो ये तो पूरी ठीक है हाँ? पूरी ठीक है कोई नहीं बोल रहा
May I please, your lordship? My lord, this is regarding compassionate appointment, my lord. My case has been rejected by the SLC due to lack of vacancy, my lord. So, my lord, as per clause 15 of OM dated 1/6/2015, my lord, my case may be considered.
When was it rejected?
2017, my lord, page number 31, my lord. Relevant portion, page number 33, my lord.
2017.
My lord. I have not got that time, my lord, SLC minors.
When did you receive it?
2021, my lord. I have already stated in my petition also, my lord.
Yeah, who appears, state government?
For elementary education department. Madam.
Last,
Some other than Malan.
Yes, Begu.
Can you explain some other him today I'm briefly
as per clause 15, my lord. As per clause 15, my lord, of 1/6/2015, my lord. Simple, my lord.
You don't have the brief or what?
Yes, briefly. Please, Madam. Immediately after vacation.
What, Mr.
F.L. Lashkar, my lord.
F. L. Laskar, Learned Council for petitioner on request made by Mr. G. Beku, Learned Government. List up to the summer.
Obliged.
59.
Wait, please, your lordship. Maybe taken after vacation on
Lordship, we have
25th.
filed our affidavit today, Lordship, that is not on the record. Lordship may take it up after vacation.
Heard Mr. M.R. Kandava, learned counsel for the petitioner, Mr. B. Chowdhury, learned standing counsel assessing. Submits that he has filed counter affidavit this morning.
Yes.
Stop. Register to verify and place the same on record. If found in order,
In the meantime, I will file it.
this the matter of the
Obliged.
summer vacation.
Copy of daily list ordered.
40.
It's a contempt matter, my lord.
Yes,
Only
last
thing in the
appeal,
last
Lordship,
order, my lord, we required the finance to place instructions of the
instructions.
proposal received from the education department.
But today they have missed because their name is not shown in the
Lordship,
clause
here
window.
there's a difficulty, my lord, it's a contempt proceeding, my lord. Notice has not been served upon the contempt, my lords. Here, respondent number 9, my lords, he is not not holding the post anymore. He has been transferred, my lords. There is another
I'm
commissioner.
sorry, my lord. My lord will only have that order, man. I'm sorry, these submissions are being made. It's, my lord, Mr. A. Chalia, learned standing counsel, my order dated 15/5.
Yes, Lordship.
Chalia, Finance Department will open instruction as to the status of the proposal. Received from the Education Department, apprised this court on that day. My lord, it was not to any contemner. It was as the standing counsel. If it's not the standing counsel,
Lordship.
another thing, my lord.
No, Lordship, I am a standing counsel. Lordship,
Then he'll have to comply with this.
Lordship, that contempt number 9 is not there anymore, my lord. So,
My lord, attendant 9 is not being questioned. It's the Finance Department.
You have to find a review for this order.
The difficulty is that Lordship, sometimes what happens, Lordship,
Lordship, in a contempt proceeding
the
without
court on its own direct the standing counsel.
That I know.
That is the problem, Lordship, that
that
you
I
are
know.
facing. That is the
Well,
problem.
if the
Otherwise,
court
he is
has
not an engaged
directed-
counsel.
Once
He
the
has to
court
be
has
engaged.
given you a direction, it's your
Lordship, in
duty-
that time, I'll seek some time to,
it's your duty to
If
take
wants
the
time, my lord, no issue.
Lordship, I'll take some time regarding that, Lordship.
Okay. But
Fine, ma'am.
in Ireland, the senior counsel assisted by Mr.
Mr. my lord, Mr. Chisti would be for,
R.
120.
R. Islam, isn't that?
No, no,
Yes,
he is-
ma'am.
You
Yes,
are
ma'am.
assisted by.
Lordship, but a copy of the contempt petition may be provided
Also heard.
along with the.
he is already been given, my lord.
Lordship, if that is,
Janani,
Lordship, they can
Nishu.
show I have received
Mr.
it.
Chalia, the standing counsel, finance department shall receive instructions
In terms of,
as directed by this court on 15/5/2023.
from the Finance Department.
From the instructions from the finance department as directed by this court on 15/5/2023.
And so far as Lordship contemners, all contemners earlier, they were all retired, somewhat
You have a
transferred,
spare
Lordship.
copy,
The present,
Islam. You have a spare copy of.
Yes,
instructions?
I will give.
You
We'll give
furnish
it,
to
ma'am.
Mr.
We'll give.
Chalia.
Lordship, a copy may be provided and Lordship, a communication of the education department where they have sent the proposal, my lord, that can be handed to me. It will be
That will
convenient.
be, my lord, what is this childish things being asked for, my lord?
List after the summer.
My lord, we'll fix a date and let the name of Mr. A. Chalia be shown, my lord. in the
Lordship,
process.
am I going to be engaged in this matter? Or will I, can I be exempted also once I produce the necessary instructions?
That we'll see.
I will see you. You're not here as a contemner. You're only as a counsel.
but this also creates.
Lordship, I
sometimes-
was just assisting the court, Lordship. If
Lordship,
that is,
sometimes this kind of order also.
it is already affecting me,
difficulties
Lordship.
for us also, Lordship, from the court.
If I lose my job because of this.
My lord will
Lordship,
do one thing, my lord.
Unless we are engaged by the.
My lord will do one thing. My lord will score up my submission, my lord. Will score up this. Let the concerned people presently in the holding the office be present before this honorable. Why, my lord, engage an advocate? My lord will have that
Chalia,
person.
You get your information. After that,
Lordship,
we'll
I'll get the copy may be provided, Lordship, because the copy has not been
see.
provided.
That copy. you-
We will give it, my lord. We will give it. Much obliged, your lordship.
41.
Lordship, in this matter, new income bench have joined.
You want file in IA?
No, Lord.
You want
I want to
file,
file.
file for implement?
Yes, Lordship.
Mr.
You Ghosh, on behalf of DP Bora.
You Kosh appearing on behalf of Mr. DB Bora, place for 3 weeks time
Okay,
to
Lord.
file an appropriate application for implement of necessary parties. Praise a lot. List the matter after the summer vacation.
Obliged, Lordship.
42.
42, let them, they have to implement that
What is
present,
42?
the Bija Sodi is no longer holding the South Lordship.
No, no,
The present
Bija Sodi-
secretary is important Lordship.
Who is the
Suranjana Senapati already implicated.
Chandana director, it's a government level of government BTS he is suffering from cancer and he is
No,
no
no, new incumbent already implicated. New person already implicated.
only director is made party.
No, there was an IA
What
file.
is your problem, Chishti?
No, there was an IA file. The present director of elementary education, Suranjana Senapati,
Hmm.
she has been implicated.
Whether
Yes.
service is complete or not, Lordship.
On respondent number 2.
Yes.
Service is not complete, my lord,
Service
but
is not complete, Lordship.
but my lord, I will pray that my lord, the notice should go through the council, my lord, because
No, I cannot take that down, Lordship.
Not sure.
Until unless
No,
engaged.
Either you have one more option. You can try dusty service.
my lord,
In contempt case, Lordship.
What to do?
because my lord,
Or we can still continue with the,
my lord, that
then you can have a.
First step.
my lord, 2021 order, my lord, it is a government official, my lord.
Check the consignment records.
My lord,
Postal report.
initially, when we filed the IA, my
postal
lord,
report.
before getting the new incumbent implemented, my lord, an IA was filed. My lord, in the IA, my lord, we have represented to the new director, my lord,
That's
and
fine.
that IA was that was duly served. That representation was duly served. My lord, now 26/4, we have taken steps, my lord.
6/9/6/2023 says no ID card, no unserved notice.
Lord, this is a government official, my lord, well, if the notice, if the dusty may be permitted, my lord, that would be better, my lord. Otherwise, the standing council can inform that there is a,
Or at least, Chishti, can you at least inform?
yes,
I can inform, but I can inform over Lordship.
that
But I
would do
cannot
suffice.
approve.
I'm not passing that order.
Yes, I can, your
My
Lordship
lord.
may not pass over, I will inform.
My lord, because my lord, 2021 order, my
Then I'll
lord,
say award service report of respond number. two.
Yes, Lordship may
My
do it
lord.
like that.
Third H Gupta, learned counsel
Well.
for the petitioner. Award service report on respond number 2 and list the matter after the summer weeks.
no, can
Mr.
it be,
Chishti, you can,
I will inform, yes.
no, can it be before, my lord, because 2021 order, my lord, the person, he was terminated,
award service report today is Thursday,
my lord,
then,
my lord, after,
Mm.
date may be fixed.
no, I'm not fixing this after the summer
No.
vacation. You can make the mention.
of it.
Wait, please, your lordship.
Lordship, kindly peruse the order dated 7/12/2022, 12/2022.
Yes,
Then Lordship 1/3/2023. Then Lordship 16/5/2023. Then Lordship 5/6/2023. Lord, instead of complying this court's order, my lord, the director, the honorable court has set aside the appointment of the provincialization of the private respondent.
Here, the director has already written to the government for his approval, but in the meantime, the opposite party has already filed an appeal. So, my lord, the government is yet to Lordship reply.
No,
against the-
my lord, only now the respondent, my lord, I have a doubt, my lord, because he is without complying the order, my lord. He has also done hearing.
Until
He has
and
no
then- he is
authority
the
to hear
secretary,
the
he is the
private
commissioner
respondent.
secretary is not a made party, Lordship. Now the director
No,
has already
my
written to
lordship,
the
kindly see
secretary.
the page 20. Page 20 of my petition, my lord. Order is to the director, my lord.
But director cannot pass until and unless he approved by the
Why the
secretary,
director had
Lordship.
conducted hearing, my lord, after set aside, the honorable court has set aside the order of the private respondent. But on 16/5, the
And
director had
Private respondent
conducted
has already
hearing.
filed an
of the-
appeal, Lordship, against that order.
No, my lord, only I has been filed for conduct
Whatever,
of delay.
Lordship, delay may be there, but the appeal has
it
been filed.
says director to consider the case of the petitioner for provincialization
Yes, Lordship.
as a language teacher
My lord,
in so and so school. So when he's considering, he can call the petitioner and hear the petitioner.
no, my lord, here, but all, every hearing also completed.
So let us see what the
Yes, after
director.
hearing a report has been sent to the government for his approval,
my
that
lord,
is waiting for that director. As soon as that approval comes, he will pass. But
That
in the
is
meantime,
why
the appeal has been
Government
filed.
is a party.
No, Lordship.
Government is also party, my lord, in this case.
The content is no, only director is a party.
No order, specific order to the director, my lord.
Then you produce the director's letter, then we'll close this contempt.
Yes, yes, Lord. I'll call you then, Lordship. Yes.
Heard Mr. M.R. Khandagar, learned counsel for the petition. Mr. S.M.D. Chisti, learned counsel for the sole respondent.
Yes, Lordship.
Submits that the director, which director,
Director Elementary, Lordship.
elementary education, has already furnished the report.
Has sent a communication to the
Has sent a communication
to the commissioners, to the
the-
government Lordship for its approval.
government for approval of,
That I think that hearing was taken place, Lordship, that some report that.
okay, then cancel it. SMD Chisti, learned so and so, submits.
I'll produce the instruction next Friday,
Place
Lordship.
for and is, okay, on request made by SMD Chisti, and counsel for the sole respondent, list this matter on 30. To enable him to receive instructions.
Yes.
That day you produce it.
Yes.
My lord, in terms of order, the 16-5, 16-5-23. I'm up.
45.
Close already.
May I please, your lordship? On last occasion, for which time was granted to file affidavit, lordship. But no affidavit.
Yeah,
was
Lordship,
filed.
some matter has been sent to the senior citizen for some legal views. So we need further time, Lordship, because
Heard Mr.
another 4,
Yes, Salam, lordship.
let it come after
Yes, Salam,
vacation.
learned counsel for petitioner, on request made by SMD.
Like, after 4 weeks,
Mr.
Lordship, it will take some time.
Learned counsel, appearing on behalf of the sole respondent, is allowed 3 weeks time.
Yes,
Yes,
not to
yes,
affidavit,
yes.
Lordship, because the legal views, a lot of,
This after the summer.
Yeah.
vacation.
Lordship, date may be fixed, lordship.
No,
it will come, Lordship.
47.
May I please, your lordship.
Mm.
Lordship, pursuant to the order dated 5/9/2022, we have taken steps upon the respondent number 456 by way of Dusty.
notice. is
Regarding that,
complete.
lordship, I have submitted affidavit also, lordship. Service is complete, matter may be fixed for admission, lord.
What matter is this? With petition,
With petition.
where's your affidavit? Where's the notice?
Lordship, kindly take up my additional affidavit, lordship. Page
Yes.
number 57, lordship. Page 57.
4, 5, and 6.
4, 5, and 6.
Who are the respondents 4, 5, and 6?
4 is CMJ University. 5 is Registrar CMJ University. 6 is Verification Insert CMJ University.
Where is that?
Page number 57 itself. lordship.
Who received this?
Lordship, seal is there, lordship. Receipt CMJ University. This is the seal of the CMJ University,
I
lordship.
can't see the seal here.
Lordship, may I please the original copy, lord? This is the original.
Okay, heard Mr.
M. Ahmed.
M. Ahmed, let me counsel for the petitioner. Peruse the affidavit filed by the petitioner. With regard to service of notice on the respondents, 4, 5, and 6.
4, 5, and 6, my lord.
Stop. By Dusty service. Stop. As affidavit is accepted. Notice on respondent 4, 5, and 6 shall be deemed to be complete. With the matter after the summer vacation in the admission column.
Highly obliged.
49.
May it please, your lordship, my lord, this contempt is filed against the writ petitioner, my lord. Lordship may have a look in the page 19, my lord. Bottom, my lord, last paragraph. Page 19, last paragraph.
Have you filed your appeal? Have you filed your appeal?
My lord, I am respondent, my lord. I was private respondent in the writ petition. The order against me, my lord, interim was continued. But the appeal was not filed by the petitioner, record I have been suffering. So I filed this, my lord, contempt against the writ petitioner, my lord.
How can you file a contempt?
My lord, what happened, my lord,
When you
especially
are not the writ petitioner?
lordship directed, my lord, the petitioner to file an appeal. It is a directory, my lord.
Then you cannot file, you cannot file a writ petition?
Yes.
How can you file a contempt? You withdraw this with liberty to file appropriate application.
I don't know.
How can you file a contempt?
I filed contempt on the basis that the court is directed to the writ petitioner to file a appeal. And he did not file a appeal.
That's why you
And
can
accordingly-
come, you can always approach this.
I
court.
am and the last line matter, page 20, till the appeal is disposed of, the interim order dated so and so passed by this court shall continue. And accordingly, I am.
What does the order say? Appeal shall be filed within the period of 10 days.
Yes, madam, that was
From
directed
today.
to writ
If it
petitioner.
is not filed within 10
No.
days, what happens?
What happens, madam, ultimately, what happens, madam, but the official respondents, my lord,
No, you can file a writ petition, not a contempt.
obviously,
Huh? What do you want?
my lord, drew liberty.
You are Mr.
M. Hussain.
Mr. M. Hussain and the counsel for the petitioner press for withdrawal of this writ petition with liberty to file an appropriate application. Praise a lot. This contempt petition is accordingly closed on withdrawal with liberty as well.
No, like.
May I beg your lordship? Lordship, I for correction of the name of the respondent number 8 of the writ petition.
Where? In the course title
Lordship,
or
lordship or last order passed by this honorable court on 24/5/2023, which is annexed in the ILOts.
where's your main writ petition?
Lordship, in writ petition page 9, respondent number 8.
Patra Kandabura.
Lordship.
What should be the name?
You have written.
How is this supposed to be corrected?
Lordship Bhakta Kumar Bora instead of Bhadrakanta Bora.
Instead of Bhatrakanda Bora, Bhatra Kumar Bora.
Bhakta Kumar Bora.
Let's see your writ petition. See your writ petition, page 9.
Lordship.
What is it?
Bhadrakanta Bora.
So, unless this one is corrected, how can you make a correction?
Lordship, kindly allow me to correct.
This is disposed of.
No, Lordship, notice issued.
Notice issued.
Lordship.
Then you can file an IA for correction of the course title.
Yes.
That is the only alternative.
But I have failed correct.
Lordship.
After that, you can file this. You
That's-
can withdraw this with
Lordship.
liberty to file afresh.
Lordship.
MS,
You have written.
you are recalled in the council for petitioner press for withdrawal of this present IA. Then the council appearing for the applicant. With liberty to file afresh. Praise a lot. I is dismissed on withdrawal with liberty as well.
Defense kitam, no?
Finish.